అందితే జీవన సౌదాలు. చదువు మనిషికిస్తుంది మనోధైర్యం, చదువు మనిషికిస్తుంది ఉన్నత స్థానం. చదువు మనిషికిస్తుంది మనోధైర్యం, చదువు మనిషికిస్తుంది ఉన్నత స్థానం. అందిల మెక్కిస్తుంది కీర్తిని గుప్పిస్తుంది, అందిల మెక్కిస్తుంది కీర్తిని గుప్పిస్తుంది. చదువుకునే రోజులు అందరికీ అందితే జీవన సౌదాలు, అందరికీ అందితే జీవన సౌదాలు. థ్యాంక్ యూ.
థ్యాంక్ యూ సార్. వన్ మోర్ సాంగ్ బై వెంకటాచారి సార్.
Friends, those who did not register their names, we request you to register and take the badge and also the material. I request you, whoever not registered their names, please, I request register their names in the counters provided outside of this hall venue, and then that is better. Whoever missed, no, please, I request you all.
Hello. 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 Hello.
పిల్లల్ని పిల్లల్ని కనగలం కానీ వాళ్ళ తలరాతల్ని కనలేం కదా.
కానీ నా కొడుకు తలరాతని నేను రాస్తాను.
అదెలా?
ఆస్పిరియాలిటీలో భూమిని వాడి పేరు మీద రాస్తాను. మనం వాడికి జీవితం మాత్రమే ఇచ్చాం, కానీ వాడికి నచ్చిన జీవితాన్ని ఆస్పిరియాలిటీ ఇస్తుంది.
A one-stop solution for all real estate services. Aspiriality Wealth Creators, Hyderabad.
పిల్లల్ని కనగలం కానీ వాళ్ళ తలరాతల్ని కనలేం కదా.
కానీ నా కొడుకు తలరాతని నేను రాస్తాను.
అదెలా?
ఆస్పిరియాలిటీలో భూమిని వాడి పేరు మీద రాస్తాను. మనం వాడికి జీవితం మాత్రమే ఇచ్చాం, కానీ వాడికి నచ్చిన జీవితాన్ని ఆస్పిరియాలిటీ ఇస్తుంది.
A one-stop solution for all real estate services. Aspiriality Wealth Creators, Hyderabad.
Friends, on behalf of All India Lawyers Union, Telangana State Committee, I am welcoming you all to this national seminar, Constitution and We the People. I am C. Ramachandra Reddy. I am Secretary of Hyderabad Committee of AILU, All India Lawyers Union. It is a pleasure for me to invite all of you for this national seminar on Constitution. You know well, all of you have registered your names for this program, entire day-long seminar, which is most crucial topic nowadays. Constitution, what is the present trends and all that. The different dignitaries who are here, who are present here, they will enlighten all of us about the basic features of the Constitution and the present situation and the structure, federalism and secularism. Different topics will be taken up in 3 different sessions. Primarily, initial session, the inaugural session will be our Honorable Justice Lao Nageshwara Garu is here. We are very happy, fortunate Justice Lao Nageshwara Garu here. First of all, I request our Sri Kolli Satyanarayan Garu, President of All India Lawyers Union, to come over onto the dais. He is the President of All India Lawyers Union, Telangana State Committee, and he will preside over the inaugural session. I request the Honorable, our Chief Guest, Justice Lao Nageshwara Garu, former Judge Supreme Court of India, to come on to the dais. We welcome you, sir. Justice Lao Nageshwara Garu was advocate here in our High Court, late Supreme Court advocate, and then became the Supreme Court judge. And we all very well aware of Justice Lao Nageshwara Garu. We are welcoming Justice Lao Nageshwara Garu, who will be the chief guest, who will inaugurate this national seminar on Constitution and We the People. I request Sri A. Anant Reddy Garu, A. Narasimha Reddy Garu. I request Sri A. Narasimha Reddy Garu, Chairman Bar Council of Telangana, to come on to the dais. Please welcome, sir. Sir, please come. Sri K. Parthsarathi, our State General Secretary, All India Lawyers Union, who is also General Secretary of the Reception Committee. So I request him also to come on to the dais. And so I understand that Mr. B.S. Prasad Garu, because he is unwell, he could not come down to this program as of now. And Sri Vinod Kumar Garu also, the MP and Vice Chairman, Planning Commission of Telangana State also, he could not immediately come over to this program. Friends, in the part of the continuation of this program, this inaugural session, that's Honorable Justice Lavu Nageshwara Garu will be dealing with revisiting the basic structure of the Constitution, and then the other two topics, primary the second session regarding the federalism in constitutional framework and present scenario. Mr. Durga Prasad Garu will preside over, and Mr. John Brittas, MP Rajya Sabha, and Justice T. Rajini Garu will be addressing us on federalism in constitutional framework and present scenario. And subsequently, the third session in the afternoon will be secularism, 7 decades of judicial interpretation. It will be chaired by Srimati Shailaja, Advocate Women Convener, AILU Women Committee, Justice S. Muralidhar Garu, Honorable Chief Justice Retired, Chief Justice of Odisha High Court will be addressing us on the topic. So I welcome you again, once again. I request our President, Sri Kolli Satyanarayana Garu, to proceed with the program. Thank you very much.
I request Sri Narendra Reddy Garu to offer a bouquet to Sri Justice Lavu Nageshwara Garu. I request Mr. Praveen to come and offer a bouquet to Sri A. Narasimha Reddy Garu, Chairman Bar Council of Telangana. Good morning, friends. I take the opportunity of inviting all of you to have a rather a refreshing class of Constitution of India, because this is being the seminar organized by All India Lawyers Union. We felt that the area of working of Constitution for the long 77 years had given such a result to the common public, who are expecting much basing on the Indian Constitution, because unlike other countries, it is the Indian citizens who have taken the Constitution on their own. So the very preamble of the Constitution says that we, the people of India. So that is the gist of the Indian Constitution, which promises to the common citizen of India, basing on the entire composition of Constitution, is going to show that basing on that Constitution, the people should live in India by providing all the required amenities, living life, and the guarantees which are given by the Constitution. And we all know that Indian Constitution have good number of articles where the preamble of a Constitution is going to show or reflect with regard to the democracy, socialism, secularism, and we as a lawyers union are working for those three issues. And as we lawyers, we have also incorporated the justice in our aims and objectives. And All India Lawyers Union have its own Constitution, and we function basing on the same contents of the preamble and also the guarantees or fundamental rights which are to be reached to the common public. So we are struggling not only for the advocates' welfare or the community betterment, but for the betterment of the entire society and the common public. So this is the social activities also being taken by the AILU. That's why we have invited citizens of this city also to participate in this seminar apart from the advocates. So on behalf of AILU, I feel that this is the right time to examine the constitution and its functioning for the last 77 years, the working of constitution. We accept that for the last long 77 years, the people have received some fruits basing on the functioning of the different governments, but whether the fruits those who are reached to the public are on par with the guarantees given by the constitution or not is to be verified. So this is a progress card which we have to take with regard to the service that is being given by these respective governments to the common public basing on the constitution. So previously in the year 2016 also we did the same exercise, and Justice Gopal Gowda was the chief speaker on that day, and he spoke on the subject. And after a gap of 7 years, again we are conducting this seminar. And unfortunately, All India Lawyers Union is conducting these type of seminars in the entire India. In all the states we are conducting these type of seminars, and in Telangana now today we are proceeding with this, and we have divided the subject into 3 sessions, and I request all of you to participate in the 3 sessions. And before calling our chief guest to address all of you, I request Sri A. Narasimha Reddy Garu to come and address all of us.
Today's chief guest, Honorable Justice Lavana Ayeshwara Garu, retired Judge, Supreme Court of India. My good friend, Kolu Satyanarayana Garu, President AILU, TS Committee, Parsar, the General Secretary, and all other distinguished personalities who are in this session, inaugural session, and also my dear advocates, brothers and sisters. I am personally delighted to have this opportunity to participate in the national seminar on Constitution and we the people. We, on behalf of the State Bar Council and on my personal behalf, I would like to thank the All India Lawyers Union not only for taking up this special program and also having invited me to this session. As we all know, the All India Lawyers Union has been active since its inception in the year 1982, playing an active role in highlighting the basic issues relating to the provisions of Constitution and the manner of their implementation for the benefit of the citizens of India. The selection of the main theme of this seminar, Constitution and we the people, is commendable and deeply significant. We are aware that the Constituent Assembly with the Dr. Ambedkar as a chairman of the drafting committee prepared the draft, and same was approved and came into force in the year 1950. As Dr. Ambedkar stated, the recommendation of the adoption of the Constitution, the underlying philosophy of that, ensuring the theory of equality, liberty, equality and fraternity within the framework of democratic republic state. As the preamble envisages, we the people claim the sovereignty of the nation. The system of universal franchise reiterates and gives concrete shape to the unique features of our Constitution. We as a nation feel proud that it is the same, the people, we the people, who have contributed to the sustainability and access to our democratic system. We are now the largest democracy in the world. We should appreciate the role of All India Lawyers Union in striving hard to highlight the problems faced by the people within the framework of within the democratic framework of our constitution. Issues relating to the fulfillment of directive principles of state policy, rule of law, and human rights are taken up various levels. Through the system of universal franchise, has provided for political equality, while the continuing social inequalities pose a big challenge. As Dr. Ambedkar said, we should strive to ensure social justice in order to strengthen the political democracy. The term "we the people" is also a reminder of our diversity. We are a nation of many different backgrounds, cultures, and beliefs. But we are also a nation united by a common set of ideals, liberty, justice, and equality for all. Before I conclude, I would like to say a few words about my relation with the All India Lawyers Union. Since its inception, when I came into Bar Council, not only as a member, thereafter vice chairman, chairman, from the beginning, the AILU was supporting my ideas, and fortunately, Koli Satyanarayana garu also was one of the members, really working hard to, not only for this organization, and also strengthening the system of Bar Council. So we have same ideas and like-minded. Any program for that, we were together, and always I used to support AILU, because my main intention is that I came from village background. So once I entered, it's our prime duty, Bar Council prime duty, to go legal education programs. So sometimes I find it was very difficult to take up the programs on my own along with the members of Bar Council. Certain issues were very to take up. So always I requested Koli Satyanarayana garu, Vidyasagar garu, let us work together. They also they used to say, let us do this, that. We used to work like that. So only our intention is to educate the advocates about the various issues, subject like this, today's program. And so my personally I feel that this is an occasion to say a few words about our chief guest, Lav Nageshwar Rao garu. After a long time, I attended one program of him. I think Justice Nageshwar Rao was one of he was a chief guest in M.R.K. Chaudhary garu's junior, Nageshwar Rao garu. At the age of young, he expired. Memorial lecture was there in the public garden. So Ganta Ramarao, being a vice chairman and my colleague member, informed that, sir, let us go to that program. Myself and Prakash Reddy and Ramarao went there. I surprised to see that how much he developed the subject, I cannot even express in words. Nearly 3 hours, 4 hours discussions and deliberations. Honorable Justice Nageshwar Rao garu could not get the time, proper time. for the inaugural speech, whatever the final chief guest speech. So ultimately, he has to reach the airport within a period of one and a half hour. So being a last speaker, he started giving his lecture. I never forget in my life. Even Prakash Reddy, being his colleague in Supreme Court also, he expressed lot of day, so only by God gift we'll get that knowledge. On that day, continuously he made a speech, really wonderful speech. That's how I never forget his speech. So he himself present in this seminar to give his speech. Really, everybody is fortunate here to hear his speech. And thank you very much, sir, for having given consent to be here in this session. I'm glad to see that eminent practicing advocates and legal experts and the intellectuals are here to participate in today's seminar. I'm sure that the deliberations will be fruitful and the purpose will be served. Thank you, one and all.
Today, our Honorable President Sri Vidyasagar and also the should be among us, but due to his other circumstances, he had been to US. So he sent a message which will be displayed to all of you to look at the screen. I request the organizers to display the
Yes, sir. Yes, sir. Yes, sir. Okay. Yes, sir. Yes, sir. Yes, sir. Yes,
Okay, he's not connecting with the online, and I request Sri Arun to read out the message sent by Sri Vidyasagar Garu.
This is the welcome address by Sri Hon G. Vidyasagar Senior Advocate Garu. I am reading it out. It gives me great pleasure to speak to all of you this morning as President of the Reception Committee of today's National Assembly, Constitution and We the People, organized by all the lawyers union in Telangana state. For compelling reasons, I am physically not present, but thanks to technology advancement, I am addressing the same from San Jose, California, USA. This event of joint efforts of AILU, Telangana unit for last 2 months under the guidance of Mr. Kolli Satyanarayana, President, and Mr. K. Pardasarthi, General Secretary of the unit. We, the people of the country, have enacted the Constitution for our country and brought it into force on 26 January 1950. The Constitution enumerates legal rules and principles which govern the government of the country and fundamental law of the country. It is indeed the resultant of parallelogram of forces, political, social, and economic, which operated at the time of its adoption by the Constituent Assembly comprising of eminent personalities in all walks of life. The basic philosophy of our Constitution is the preamble to the Constitution, We the People. Therefore, we have chosen to organize the seminar on this topic, which will be relevant for all times to come. In the recent years, we are witnessing a significant change in our country in all the three wings, namely judiciary, legislature, and administration. Justice L. Nageshwar Rao Garu, Supreme Court Judge retired, was kind enough to accept our request to address the seminar on the topic, revisiting the basic structure of our Constitution. Mr. John Brittas, Member of Parliament, and Srimati Justice T. Rajani on the topic, Federalism in Constitutional Framework, and Mr. Justice S. Muralidharan on secularism, 7 decades of judicial interpretation. All the dignitaries have accepted to participate in spite of their busy schedule. The Advocate General, Mr. B.S. Prasad, has been kind enough to be in the forefront in encouraging the organizers of the seminar. Distinguished invitees, members of AILU, and all participants are requested to participate in the seminar and contribute to the consolidation of aims of AILU in organizing such seminars. I am confident that everyone here will be benefited by the presentation by the distinguished speakers on various topics and broaden our perspectives. In conclusion, I thank one and all who have contributed for organizing a seminar of this magnitude. Thank you.
Thank you, Arun. I request Vadasadi Garu to give some welcome remarks for 2 minutes.
మిత్రులారా, ఈరోజు రాజ్యాంగం పైన పెద్ద దాడి జరుగుతున్న తరుణంలో ఈ సెమినార్ని ఆర్గనైజ్ చేయటం అవసరం అనేది మేము ఈ రాజ్యాంగాన్ని రక్షించుకోవటమే ప్రధాన లక్ష్యంగా పెట్టుకొని ఐలు పనిచేస్తున్న పరిస్థితి ఉంది. అందుకు అడ్వకేట్స్తో పాటు వేరియస్ ఫీల్డ్స్లో ఉన్న ఆల్ సెక్షన్స్ ఆఫ్ పీపుల్ని కూడా మొబిలైజ్ చేయడానికి కొంత ప్రయత్నం, చిన్న ప్రయత్నం చేశాం. ఇది సరిపోదు. భవిష్యత్తులో దీన్ని పెద్ద ఎత్తున ప్రజల్లోకి తీసుకుపోవటానికి, అవగాహన కల్పించడానికి ముఖ్యమైన ఉద్దేశంతో ఈ సెమినార్ని ఆర్గనైజ్ చేశాం. కాబట్టి నేను ఎక్కువ సమయం తీసుకోకుండా ఒక 2 నిమిషాల్లో పూర్తి. Guest on the dais, respected friends and members of the legal fraternity and other secular democratic citizens who are present here. I, on behalf of All India Lawyers Union, Telangana State Committee, welcome you all. Today we are passing through a stage where a foundational document of our governance, that is Constitution, is in danger, getting undermined, getting undercut from within. For more than a decade, there are several attempts to assault on the Constitution. It appears for a common observers that a parliament has right and authority to amend the Constitution to meet the changing times. What times have changed since the adoption of the Constitution? Does we eliminated poverty completely? Does we could provide employment for all able, educated and qualified? Are we able to feed the hungry stomachs? Recently, National Family Health Survey report revealed it recorded that more than 52% of our population, particularly women, are anemic. Then what is the need to change the overall Constitution, which we adopted to govern the country till we overcome all the problems, issues just mentioned above? It is more astonishing that a parliament is being used merely as an instrument to carry forward the non-parliamentary undemocratic agendas set out by some sittings somewhere. It is in this context the AILU decided to work towards strengthening the Constitution and also by generating the awareness about the Constitution and its role in our daily lives and also in the life of the nation. It is with this aim and understanding we are organizing this national seminar today here. We are all thankful to the speakers who are graciously accepted our request to present their thoughts on various aspects of the. I personally, on behalf of AILU Telangana State Committee, warmly welcome Sri L. Nageswara Rao Garu, former Judge Supreme Court of India, who is known for his apparent and unequivocal stand on certain constitutional issues. I also welcome John Britta, Member of the Parliament, Srimati T. Rajani Garu, former Judge and Judicature of Telangana and Andhra Pradesh, currently serving as a national member of. I also extend special note thanks to Justice Muralidhar Garu, who recently retired as Chief Justice of Odisha High Court. He made his mark on both on the bench and bar since the days he took up the Bhopal gas affected people's issue. This endeavor could not have been made possible without generous support and extended by several individuals, legal numerous, senior counsels, and especially Advocate General, Government of. We extend our warm gratitude and regard. Thank you.
Now it is the time for inviting our chief guest, Sri Lau Nageshwara Garu, Justice Sri Lau Nageshwara Garu, to address all of us. Before that, a small request with the Justice Nageshwara Garu, because press people are pressurizing for release of souvenir before your speech, for ceremonious release of souvenir, because it's not yet completed, totally completed, not, but now I request Sri Justice Lau Nageshwara Garu to address all of us.
Mr. Narasimha Reddy, Chairman Bar Council of Telangana, Mr. Sachinarayana, President AILU, Mr. Parthasarathi, and my dear advocate friends, a very good morning to you. When Mr. Parthasarathi came and met me and asked me to address on basic structure in a seminar to be organized by AILU, I was telling him that it might be difficult for me to come in view of so many engagements, but when he said that there will be a large number of advocates who would be interested in learning about the Constitution and the basic structure, I was also thinking that I should somehow or the other make time to come and share my views on the Constitution with you all. I appreciate the efforts of All India Lawyers Union in conducting a seminar like this, in trying to create awareness not only in the legal fraternity but also amongst the citizens about the Constitution and what it says and what it is for. I'm also told that AILU conducts regular workshops for lawyers even in the districts, not only restricted to Hyderabad. I'm very happy to learn that an academic exercise amongst lawyers is being conducted by AILU. There is something which is lacking in the Indian legal profession, which is there in most of the developed countries, that is continuing legal education for lawyers. We do not update ourselves as legal professionals with the development of law. We come out of law colleges, stop reading books. We only thrive on practical experience, and most of us also experiment on people who come to us with their briefs. It is high time that the lawyer should realize that they should be well equipped, at least with the branch of law in which they are practicing. Having said this, I am asked to speak on this topic of revisiting the basic structure. As it's a mix of lawyers, citizens, and lawyers practicing not only in the High Court but in the civil courts, I will tell you the story of basic structure. That will be, I think, a better way for all of you to understand what this basic structure and the Constitution is all about. After a long struggle for independence, a time came in the 1930s where there was a talk of India becoming independent from the British yoke. The Government of India Act 1935 was passed, giving limited rights to people of India, elections being conducted in the provinces. It would be interesting to learn that it was only persons who were graduates and income tax payers who were permitted to vote for elections under the Government of India Act 1935. Then a Constituent Assembly was constituted. This was in the United India, where Pakistan was also a part of India. Elections were conducted, and in the elections about 350 people were elected to the Constituent Assembly. Most of them were from Congress. A few of them were from the Muslim League. Persons who came from the Muslim League wanted a separate Constituent Assembly for themselves. They said, let there not be one Constituent Assembly. And thereafter, as you know, there was partition, and the Independence of India Act was passed. There was an indirect election to the Constituent Assembly which had about 295 people. And this Constituent Assembly was the Provisional Parliament. As you all know, 14th night, it was the 15th of August 1947, when India became independent. But prior to that, in 1946 December, the Constituent Assembly started functioning. The Constituent Assembly appointed a drafting committee under the leadership of Dr. B.R. Ambedkar, who studied his law in UK. And Dr. B.N. Rao was given the task of drafting the Constitution and placing before the drafting committee. Dr. B.N. Rao visited various countries in the world, and then he borrowed provisions from the US Constitution, Irish Constitution, principles from UK, the Weimar Constitution, which is a German constitution. They even took provisions from Switzerland and then, well, Russia also. And there are some smaller known countries whose constitutions were read by B.N. Rao when he made recommendations as to how this Constitution of India has to be. After about 3 years, almost 3 years, 2 years, 11 months of discussions, after the preparation of the Constitution, the Constituent Assembly approved the Constitution on 26th of November 1949. 26th of November each year is celebrated even now as the Constitution Day, because that is the date on which the Constitution was passed by the Constituent Assembly. Though it is not connected to the basic structure, the final speech that was made by Dr. Ambedkar on 26th of November 1949 is memorable. He said, "We are politically independent now. People can exercise their votes to elect people, their leaders. People are now governed by themselves. You do not have a foreign power governing. But the question remains as to whether we have really got independence. He said, as long as this country is divided on the basis of caste, religion, and region, there is no independence. At that point of time, there were about 3,500 castes. He said that unless people rise above these vociferous tendencies, there will be no independence in India. And he said that a country that is going to be governed by ourselves is going to be a disaster, and there is no complaint that we can make against anybody else. At least earlier, we could complain against some foreign force ruling us. So, gentlemen, ladies and gentlemen, keep it in mind. All of us are educated. All of us at least project ourselves to be civilized. It is high time that we rise above all these considerations of caste, religion, and even the disparity in the society also has to be forgotten. All of us are equal. I'll speak more about it when I come to the preamble of the Constitution and the provisions of the Constitution. So the Constituent Assembly completed its job. It finalized the Constitution. And 26th of January 1950, you know, that is the Republic Day. On that day, the Constitution started working. Elections were conducted for the first time in this country in the year 1952. And Congress went to polls by saying that there is going to be a social revolution that will be brought by the party. They said that agrarian reforms would be there and justice would be done to a poor man in this country. On this promise, elections were conducted in 1952. Congress came to power. At that point of time, it was still the Constituent Assembly, which was the provisional parliament, which was taking decisions. The Zamindari Abolition Act was passed. Zamindari Abolition Act was challenged in the high courts of Bihar, Madhya Pradesh, and Uttar Pradesh. The Bihar High Court struck down the Zamindari Abolition Act. The Madhya Pradesh High Court and the Uttar Pradesh High Court, they upheld the Zamindari Abolition Act. Zamindari Abolition Act was struck down on the ground that it violated the fundamental right of property. Persons who had a right in property approached the High Court, and the High Court upheld their contentions that it was violating their fundamental rights. The Supreme Court had to take up the first case in so far as the Zamindari Abolition Act is concerned, and it was a judgment, if you can note down, Shankari Prasad. I'll just mention about 4 or 5 judgments. I'll not trouble you mentioning about too many judgments here. If it was a law college, I would have told you about more judgments on the Constitution. By this time, the Constituent Assembly, which was the provisional parliament, carried out the first amendment to the Constitution of India. By this amendment, there was an amendment that was made to Article 19 pertaining to freedom of speech, and our Constitution, which has about 395 articles and 8 schedules, which is the longest constitution in this world. There's no other constitution which has so many articles. A 9th schedule was added to the Constitution by the first amendment, and the 9th schedule said that any law made by the legislature or parliament, if it is put in the 9th schedule, it cannot be challenged in any court of law, and the court of law cannot set aside or declare it as unconstitutional on the grounds that it violates the fundamental rights. So the 9th schedule was introduced because Pandit Nehru felt that the courts were stepping more than the jurisdiction, more than whatever it is given to it, and when the parliament was interested in making agrarian reforms, the courts have been a stumbling block in carrying out the policies of the government. So the first amendment was challenged before the Supreme Court. All these judgments of the 3 high courts which I mentioned, which dealt with the Zamindari Abolition Act, were brought to the Supreme Court. rights that were guaranteed to the citizen are supreme, and they cannot be tramped by the parliament by making amendments and saying that they are placed beyond judicial review. That is, courts cannot look into the laws that are made by the parliament. The 5 judges bench of the Supreme Court said that there is nothing wrong with Parliament exercising their power. They upheld the First Amendment and they dismissed the petitions that were filed in challenge to the First Amendment. Though not again connected to basic structure, the other amendment that was made by the First Amendment pertained to placing restrictions on the fundamental right to speech. There was a case that came from the province of Madras, that is the state of Tamil Nadu, where there was a communist-run newspaper which published some articles against the government, and the government said that they have committed sedition. So the newspaper took the ground that there is a fundamental right of speech and nobody can stop the press from writing what the truth is. So then the court had to interfere and then say that the act that was made by the government of Madras was in violation of 19. That made the parliament make an amendment to Article 19 by placing reasonable restrictions in Article 19. After the First Amendment was upheld, there was a rush for all the laws that were made by the legislatures to be placed in the 9th schedule so that it is placed beyond the jurisdiction of the court. Nobody can challenge these laws. The numbers swelled to about 250 laws that were made by the parliament, making these laws go out of the reach of the court's purview. Court cannot look into that law and say that this law is unconstitutional. There was an amendment that was made which is called the 17th Amendment, again placing several laws from Punjab and various other states, Rajasthan, etc., which was again challenged by people who have properties, saying that these laws that you're making would be affecting our rights of property, and our properties are being taken away by legislations. The Supreme Court again met, upheld the 9th Amendment, upheld the 17th Amendment, and they said that the Parliament has the power and there's nothing wrong with what is being done. The judgment of 5 judges was decided with a laser-thin majority of 3:2. There were 2 judges who dissented, and they said that the 17th Amendment might not be constitutional. 17th Amendment was revisited later at the behest of Chief Justice Subbarao, who constituted a 11-judge bench and decided whether the 17th Amendment is constitutional or not, and in a case called Golaknath. The point that was being argued and the Supreme Court was saying earlier was, there is a provision in the Constitution which is Article 13(2). Article 13(2) declares any law that is made in violation of the fundamental rights to be void. The argument that was advanced earlier was that even if you are making an amendment to the Constitution, that would be law falling under Article 13(2), and if fundamental rights are violated, then the court should interfere. Earlier, in Sajjan Kumar, the court said that an amendment made by the Constitution under Article 368 is not law that is mentioned in Article 13. That is a constituent power that is given to the Parliament. So Parliament has power to amend the Constitution. But the 11 judges bench, which was headed by Chief Justice Subbarao in Golaknath, held that an amendment made to the Constitution under Article 368 is also law in Article 13(2). And if any amendment that is made to the Constitution is violating fundamental rights that are given to the citizens of this country, then the court has the power to strike it down as unconstitutional. This is again a judgment of 6 judges being in the majority and 5 judges not accepting what the majority has said. By saying this, the 11 judges declared the earlier judgments as wrong, but it applied a principle of prospective overruling following some American judgments, saying that the judgment that is delivered by the court would be applicable only from that date, not setting aside whatever was done in the earlier judgments of the Supreme Court. Now comes the setting for Keshwananda Bharati. After Golaknath was decided, the government immediately swung into action, and they made 3 amendments to the Constitution, 24th, 25th and 29th amendments. The effect of these amendments that were made, 24th, 25th and 29th, is saying that the Parliament would have power to amend the Constitution in the manner in which it likes, and adding a proviso to Article 13(2), saying that it applies only to the fundamental rights in 13 and not to the amendment to the Constitution, and taking away judicial review. So with these amendments that came into force, a 13 bench had to be constituted because Golaknath was decided by 11 judges. And Keshwananda Bharati, which ultimately decided the basic structure doctrine, went on for about 60 days. Long hearings were conducted. It was decided during the course of hearings of Keshwananda Bharati that the correctness of the judgment of Golaknath is not being looked into by the court, but the interpretation of the word amend in Article 368 was the subject matter of discussion. So we'll have to understand the background of Article 368 and other relevant provisions of the Constitution before we proceed further, how we understand basic structure is all about. Our Constitution, as I said, contains about 395 articles. The most important chapters that we are concerned with here are Part 3 and Part 4 of the Constitution. Part 3 guarantees to all citizens of this country certain fundamental rights which are basic rights for existence of a human being. You have right to equality and equal protection of laws in Article 14. You have the fundamental freedoms in Article 19. You have a right to life in Article 21. And you have other rights which have been mentioned therein. I will not go into all those one by one. And the most important right that is given to a citizen in this country is Article 32. Article 32 is a right that is guaranteed to every citizen to approach the Supreme Court of India for issuance of a writ whenever there is a violation of a fundamental right, assuming somebody is being illegally arrested and his right to life is being affected. Somebody's freedom of movement is being trampled upon. Somebody's freedom of speech is being throttled. He can directly approach the Supreme Court and make a grievance about executive action and say that he has a fundamental right which has to be enforced by a court of law. Dr. B.R. Ambedkar, while the discussions in the Constituent Assembly were going on the fundamental rights, said that if he has to pick up one article out of these 395 articles, which is the most important article in the Constitution, he said it is Article 32, which is the heart and soul of the Constitution, because it gives the power of judicial review. It places checks and balances on executive power and even parliamentary legislation, which means, in simple terms, if there is a law that is made by Parliament or a legislature which affects the rights of people and the fundamental rights are being taken away, it is Article 32 and the Supreme Court which can interfere. You have a provision under Article 26 also which confers the same powers in the constitutional courts at the states, which are the high courts. They also exercise the same powers. These fundamental rights are very basic to a democracy. For a person to say that I'm a proud citizen of this country living in a democracy, he says that I have these rights which are not there in most of the countries. I'm a free man. I can do whatever I want. I can say whatever I want without any inhibition. Now comes part 4 of the Constitution, which speaks of directive principles of state policy. There is a duty that is cast on the state to ensure the welfare of the people in this chapter 4. Both chapter 4, the part 4, which is the directive principles of state policy, and the fundamental rights are like two wheels of the chariot. The state government has to see that the welfare of the people, including those downtrodden people, is taken care of by making laws. Laws that are made under the provisions of part 4 of the Constitution is only for the purpose of improving the lot of the people, taking care of their health, nutrition, education. Everything is mentioned in part 4 of the Constitution. The tussle between the Parliament and the court from the beginning has been, the Parliament says that I am making laws under part 4 to benefit the people. Why should the court interfere on the ground that there is violation of fundamental rights? On the other hand, the theory in the protection of fundamental rights is that there is a basic right that is given to the society as such and individuals, and you could not be permitted to trample those rights. So this is the tussle which is going on. It's a healthy tussle actually. The question as to who gets supremacy is something which I will deal with a little later. So the balance between the directive principles and the fundamental rights has also come up for consideration in another case, which I just mentioned in another 2 or 3 minutes. We have this provision that permits the Parliament to amend the Constitution in 368. Why should there be an amendment to the Constitution is something which you might ask yourself. Thomas Jefferson, who is a great philosopher, the President of the United States, said that a generation is of 10 years. A generation changes every 10 years. Every generation has the right to decide what is good for themselves. We do not have a right to decide what would be good for people who are going to come into this world after 50 years. The societal changes would be there. Parameters would change. Living conditions would change. Still, the American Constitution has only 27 articles, and it has been there from 1797, except for the Bill of Rights that I mentioned. They say Constitution is a living document. Why do they call it a living document? Because you make a Constitution, and then you apply the principles of the Constitution to changing times. But would there be a need for amendment to the Constitution? There would be. As I just said, that with changing times, changing policies, changing standards of life, there might be a need for the Parliament to exercise this power of amendment. So Article 368 says that the Parliament has the power to amend the Constitution. That power is there. Now the entire theory of basic structure which I am going to speak of revolves around that power to be exercised by the Parliament under Article 368 of the Constitution of India. And what did Keshwanand Bharati do? Without taking you too deep into the case, what Keshwanand Bharati decided was, there are judgments written, so many opinions were written, even by the majority there were about 5 opinions that were written. 7:6, 7 judges who formed the majority said, you can amend the Constitution. What was decided in Golaknath, that Article 13 includes Parliament's power to amendment as ordinary law is not correct. Parliament has the power to amend the Constitution, there is no doubt about it. But You cannot amend the constitution to destroy the constitution. You cannot abrogate the constitution, which means that amendments can be made, but otherwise you cannot nullify the constitution. What does this abrogation of constitution mean? Which means that there are certain essential elements in the constitution which you call them basic features, basic structure, etc. Those cannot be touched. That's what has been decided by the majority. The other 6 judges said that where is this restriction you are reading into Article 368? If the word amend is used, that word amend also takes into its fold repeal, rescind, abrogate, destroy, demolish. Anything can be done by the parliament. Where is this parliament coming from? They are representatives of the people. So if the people feel that they want to demolish or destroy the constitution, let them do it. That's a minority opinion. Now, after this opinion was delivered by the 7 judges bench, the debate started as to what are these basic features. In the judgment itself, you'll get an indication, the preamble that you're seeing is the basic feature. What is this preamble? This preamble contains the soul of the Constitution. What does it say? That we are constituting ourselves to be a sovereign, socialist came in the 42nd Amendment, secular democratic republic. And what we guarantee to ourselves is justice, liberty, equality, and fraternity. All these words are pregnant with meaning. They are not simple words. You just see justice, social, economic, and political. Justice is not justice that is done in court. Justice, social, economic, and political. Social justice, you must have heard. Political justice and economic justice. And when you are speaking of liberty, liberty of thought, expression, belief, faith, and worship. Every religious minority should have a right to practice his own religion. Every person should have a right to speak out. Every person should have a right to develop himself into a complete individual. Liberty. Liberty is something which is very important for the existence of a human being, a meaningful existence. It speaks of liberty of thought, expression, belief, faith, worship. Equality. Equality is something which we have been talking of, which we are very proud of in this country, but I am not very sure whether there is equality in the society even today. All of you must be seeing that still there is a disparity in the treatment of individuals. That's the reason why initially I said that we will have to raise about all these. So it speaks of equality of status and opportunity. It also speaks of promoting them all. And the last one, which is the most important provision here, is fraternity. People don't speak about fraternity at all. What does fraternity say? Fraternity assuring the dignity of the individual and the unity and integrity of India. Fraternity is universal brotherhood. Fraternity is all of us thinking that all Indians are one. And then the unity and integrity of India. We only speak of fundamental rights, we don't speak of fundamental duties which is there in the Constitution. None of us speak of our duties. We only speak of our rights, we want to enforce our rights. That's for a debate on a later occasion if at all it arises. So this is the basic structure. The goal is the preamble, how this country should be governed. Apart from this, there are so many other basic structures which have been culled out by the court, which cannot be touched by the parliament. What are those? Supremacy of the constitution itself, which means that the constitution should not be done away with. Constitution is supreme. You have three wings. All of you know as law students and even citizens know that this country would be governed by three wings. You have the parliament that makes laws, you have the executive which carries out laws, you have the judiciary which decides as to whether the laws are correct or not. Apart from that, all disputes that are brought before the judiciary are decided by the court as to whether the executive is right or not. So there are three organs in this state. Judicial review. that is the right of the court to look into laws made, has been found to be a basic structure or a basic feature of the Constitution. Right to vote, because of this country being a democracy, that is a basic feature of the Constitution. Likewise, there are so many basic features about the country being secular, coming from the preamble again, and so many aspects which have been dealt with by the courts are basic. What do you mean by basic feature? Basic feature is where the Constitution cannot survive without these amendments, without these features, essential elements of the Constitution. The questions that were asked by the courts when they were dealing with this basic feature doctrine, which I will come to just a little later, is this, as to whether the Constitution can survive without these provisions or not. So what happened after the Keshwananda Bharati? Keshwananda Bharati's judgment came sometime in 1973. In the meanwhile, elections were conducted to the parliament in 1973, 1972. Indira Gandhi won from Uttar Pradesh, in a constituency by name Rai Bareli. She won over Raj Narayan in the elections. Raj Narayan challenged her election on the ground that there are corrupt practices that were committed by her. What are these corrupt practices? He said that she utilized her people working in the Prime Minister's office and the offices of the state of Uttar Pradesh and spent more money than was permitted in the election. The Allahabad High Court declared the election as void, set aside the election of Indira Gandhi. And she carried the matter in appeal before the Supreme Court. And it was vacation time. All of you know courts don't work in vacations, and the Supreme Court was having a vacation judge, and in those days only one judge was sitting in the vacation judge. Justice Krishna Iyer, whose name you must have heard, I was just told he is one of the founding organizers of this AILU. He was sitting in the vacation court, and Indira Gandhi asked for a stay, a complete stay of the judgment of the Allahabad High Court. He passed an order of a limited stay where he said that you can participate in the proceedings in the parliament, but you will not be permitted to vote. Actually, that was the starting point for everything. He said, we're not going to now give a complete stay of the judgment. We'll just permit you to participate in the parliament. That was the order that was passed. So what did the Prime Minister do, the then Prime Minister? She wanted to retaliate, and that's how there were two amendments that were brought in to the Constitution. That was 38th Amendment and 39th Amendment of the Constitution. 38th Amendment gave power to the President to declare emergency in this country, and that emergency cannot be looked into by any courts. No court can interfere with an emergency. And 39th Amendment, the election to the posts of President, Prime Minister, Vice President and Speaker are put beyond the pale of judicial review. No court can look into the elections of these four persons. So they can do whatever they want and get elected, or nobody should challenge. 39th Amendment was again challenged in a very famous case, which is now Indira Nehru Gandhi versus Raj Narayan. To start with, the lawyer community was looking at the constitution of the court. They thought that this might not come out very well. By that time, emergency also has come. 4 judges who were in the minority in Keshwananda Bharati case were on the bench in Indira Nehru Gandhi in the case which was taking up the validity of 39th Amendment. What did 39th Amendment do, which I just told you? It declares that these people's election, Prime Minister's election, cannot be challenged anywhere. Number 2, no court has any power to go into these election matters of these 4 persons. On the ground that voting rights of individuals are a basic feature of the Constitution, 4:1, Justice Bhagavati was in the minority. The other 4 judges held that the 39th Amendment was unconstitutional. Though the election appeal was allowed. So Indira Gandhi's election was upheld. We are not concerned with that, but the 39th Amendment was declared as unconstitutional by the court. What happened after the judgment of Indira Gandhi would be making a very interesting story for you all. This is something which most of you would not be knowing because this is what was happening in the Supreme Court long time back. Chief Justice Ray was made a Chief Justice by Indira Gandhi by superseding senior judges because they were in the majority in Keshwananda Bharati. Normally, Chief Justices in Supreme Court are made Chief Justices on the basis of seniority. Chief Justice Ray suddenly constituted a bench 2 days after the judgment of Indira Gandhi. 13 judges were sitting in court. Most of them didn't know why they were sitting there. They said that the judgment of Keshwananda Bharati is going to be reviewed. After 2 days of argument, Mr. Palkiwala made arguments for about 2 days, and then Chief Justice was asked by one judge sitting there, how was this bench constituted? What was the reason for the constitution of this bench? Who asked for the constitution of this bench? Then Chief Justice Ray asked Palkiwala, you asked for a review. Palkiwala said, no, why would I ask for a review? I succeeded in the matter. Then he said, State of Tamil Nadu filed a petition for review of the judgment of Keshwananda Bharati. And the Advocate General of Madras High Court, Tamil Nadu, who was there, he said that I didn't ask for a review. Then the Advocate General from West Bengal, he stood up and said, none of us filed an application for review. Then all of them went back. Next day morning, all the 13 judges assembled and Chief Justice Ray said, we are not going to take up the matter. So an attempt that was made to review the basic structure doctrine ended like this. But the relentless struggle of the government in trying to get supremacy did not stop. The 42nd Amendment came, and the 42nd Amendment was brought by Indira Gandhi again with a number of articles, again taking away the power of the court, saying that the Parliament would have the right to amend the Constitution. Article 368 itself was amended by bringing in subclause 4 and 5. There are a number of articles that were issued. This was on the basis of a recommendation made by a committee called the Swaran Singh Committee. Indira Gandhi lost election after the emergency, but came back again in 1979. And this 42nd Amendment was again challenged, and Palkiwala had to come back from America to argue this 42nd Amendment. One thing which would be interesting for all of you to note is the names of persons which I just mentioned about Keshwananda Bharati. Keshwananda Bharati is a monk in Kerala. He has nothing to do with this case. He just lent his name, and Palkiwala argued that case. Likewise, now comes 1982, Minerva Mills. Minerva Mills had a case where the Sikh Industries Undertaking Act was challenged and it was lying somewhere. That was taken up, and 42nd Amendment was challenged, and Palkiwala argued that matter and succeeded in the court upholding his arguments that the power of amendment that is conferred on the Parliament is not limitless. And it was held in that judgment that the limited power of amendment itself is a basic structure. If you transgress this, and if you go on amending constitutions and changing the nature of the character of the constitution, that's not permitted. I was hearing a lecture of Justice Rohington Nariman, where he spoke for the 10th Palkiwala Memorial Lecture. Justice Rohington Nariman is an extraordinary jurist. I have seen judges and judges while practicing law and being a judge. but there are only a few people who can be called as legends, and Rohington Nariman is one. He was associated with this case, Minerva Mills. He just joined the bar and he was assisting Palkhiwala in this case. He was speaking in that lecture. Palkhiwala, while arguing, was, it seems, giving a few examples as to why the basic structure should be a feature for the constitutional amendments to be made by the Parliament. It seems he asked the court, if Parliament has the power to amend the Constitution in the manner in which it likes, and if the Parliament decides that we will bring in some ruler like a Mughal emperor or somebody and then say that we'll hand over the country to that ruler, they can do it because they have the power to do it. Or they say that we'll change the entire form of the government. We are following the Westminster form. Or they'll say, if the Parliament says Article 21, which protects the right to life of individuals, it says we're doing away with this Article 21. If it is permissible, then what would happen to the citizens of this country is the question that was posed. I am told that Minerva Mills case, which decided, has also decided, as I already said, that the balance between Part 3 and Part 4 of the Constitution, which are crucial to the running of this Constitution by themselves, are a basic structure of the Constitution. And thereafter, there were several several amendments that were made to the Constitution. I should mention that any law made by a legislation will be tested on grounds of judicial review, because the power that is exercised by the Parliament there is legislative power, it's not constituent power. Whenever there is an amendment to the Constitution, it is the constituent power of the Parliament. Whenever there is an amendment to the legislature, it is the legislative power of the Parliament. There were some amendments that were made. I think even this state also would be concerned with one amendment. There is a provision in the Constitution, Article 371D. Article 371D gave power to the President to establish a tribunal to decide service matters in the United State of Andhra Pradesh. There is a provision in that Article 371D, which is 371D5, which says the tribunal will decide a case, and thereafter, if the government doesn't like it, it says that we can ignore it. So they can overrule the judgment of the tribunal. That was found to be violative of the basic structure, and Article 371D5 was declared as unconstitutional in the case of Samamurthy versus Union of India. There was another case which came about setting up of tribunals, administrative tribunals in Chandrakumar, where the judicial power of the High Court has been taken away when that was declared to be unconstitutional by the Supreme Court. So basic structure is something which the court has been taking resort of to protect the judicial review and the right of the citizens to go to court and get justice. Something similar to what happened in our country when Indira Gandhi lost the election, she made laws, is happening in Israel now. For most of you who might be following the newspapers, you might be knowing that there's a turmoil in Israel. For some of you who might not know about it, I'll just tell you about the background. Israel has no written constitution. The parliament in Israel is called the Knesset. There are basic laws that are made in Israel, which is not the constitution, which govern the power that is given to the government to make laws. The Prime Minister now, Netanyahu, is on a slender majority. In the Knesset, he has a majority of 64:56. 56 are the opposition members. He stitched up a coalition and is continuing. There are criminal cases that are pending against him of corruption, etc., in a magistrate's court in Jerusalem. So he came out with this idea sometime in March of 2023 that the power of the Supreme Court has to be somehow or the other curtailed. So he thought that he will make an amendment to the basic laws, something like our constitution, whereby he would include a clause which is called an override clause, which means that the court will pass a judgment and the Knesset, which is the parliament, would sit and say, it's all right, we are overriding this. So the judgment is of no use at all. And he also wanted to interfere with the appointment of judges. In Israel, there is a judicial appointment commission which consists of 9 people. Unlike in India where judges, they have a collegium where they select judges, there is a judicial appointment commission. In that judicial appointment commission, 6 persons are either from the judges or from the fraternity of lawyers, which is the advocates. 3 are from the executive. So the majority is from the judiciary and the legal profession. So he wanted to reverse that. He wanted to have more people on the executive so that the selection of judges would be in the hands of the executive, and the executive can have its own persons as judges who would not rule anything against the government. It so happened in Israel that the awareness of people was carried out by certain democratic institutions, and there was an agitation. The citizens of Israel started taking to the roads. Every Wednesday, there used to be some sort of a demonstration where people were saying that citizens' rights have to be protected. These demonstrations continued for about 36 weeks. It was almost reaching a crescendo at some point of time. About 3-4 months back, I got a call from Israeli Democratic Institute, which has been there from 1930. They wanted me to go and then speak about democracy and how the constitution works in India and what is this basic structure principle. So I went to Jerusalem. Before the conference took place the next day morning, in the evening, I was told by Professor Yaniv Rosnai, he is a person who did his research on basic structure and has written a book on basic structure. He said, Justice Rao, let us go and then visit and then see the demonstrations happening near the president's house. We just walked up, and there were about 30,000-40,000 people of all ages. They were just having some placards in their hand that there should be rights of the citizens which should be protected. And they were walking. Professor Yaniv asked me, you pick up anybody from this group who are demonstrating, ask them why they are demonstrating. Ask them what the problem is, why are they on the streets now. All of them are very well-educated people, they have their own lives to lead. So I just picked up an elderly couple of about 60 years. I just stopped them and asked them, what's the problem? Why is this demonstration going on? They told me, 5 minutes they explained to me, what is this override clause? How is it affecting the rights of citizens? If the power of judicial review of court is taken away, what would happen in a democracy? So it would become a dictatorship. Then I asked them, what do you do? One of them said that he's a carpenter. And his wife said that, I don't do anything, I'm a housewife. This is the level of awareness and consciousness of the people in Israel. After the conference was over, midnight I got a call saying that, Justice Rao, you have to leave early in the morning because tomorrow there is going to be a complete Bandh of Israel. I reached the airport, all the flights were stopped. With great difficulty by evening I somehow or the other came out. But what made me think was this, which is a question which I want to pose to you. How many of you would think that such a thing would happen in this country? If at all, there is some law that is made now saying that there can be no case against Prime Minister Modi. Another law that is made saying that Supreme Court's powers are taken away or the High Court's powers are taken away. anything that is done by parliament or executive would be supreme. Would we take to the streets? I don't see our reacting like this. All of us are very well educated. All of us know that we have rights to protect. All of us know the importance of the Constitution, but still we do not question because we haven't learned to question. I think this is something which we should imbibe in ourselves. Whenever there is an act which is oppressive, we should be the first to raise our hand, which we never do. So, the lesson that we learn from Israel is that all of us not only should react, but also create awareness among the people about the importance of the Constitution and importance of basic structure. I'll also tell you what happened after that. There were discussions. In Israel, the defense minister was against these amendments. In Israel, there is a problem between the Jews and the Arabs. There's always a problem in the Gaza Strip. It continues, and then there is some sort of a internal strife which is going on. The Attorney General of Israel, unlike our Attorney General here, is an independent person. The Attorney General of Israel said that this legislation is not correct. She didn't support the government. Like a government leader, can the government leader say government is wrong? She said no. What is being done is wrong. The defense minister said no. The president said no. President is a nominal president there. But still, the prime minister wanted to proceed. In spite of such demonstrations, he made law. The Knesset made law in June. The law, though has been scaled down, is to the effect now that though the Supreme Court has power of judicial review over parliamentary legislations, it cannot set aside any legislation on the ground that it is unreasonable. So, which means that you are clipping the wings. It says that your powers are restricted. The second one is relating to exactly what Prime Minister Indira Gandhi did then. Netanyahu has brought out a law by saying that the Knesset would decide as to whether a person should be the Prime Minister or not, in spite of some cases being there against him, because the Attorney General was saying that you should not be the Prime Minister because there is a criminal case against you. So he brought out that law also to ensure that he will not be sent out, trying to protect himself. These two laws were challenged in the High Court of Justice, as they say in Israel, which is the Supreme Court. The Supreme Court there has 15 judges. And these 15 judges, in the normal course of business, they sit in a division of 3 judges each. But to hear these two cases, they sat all of them together, en blanc is what we say. So 15 judges sat and then they heard arguments. September 12th, arguments were heard by the 15 judges in respect of this unreasonable clause. And last Thursday, that is the 28th of September, arguments were heard by a 11 judges bench headed by the Chief Justice in respect of the law that relates to protection of the Prime Minister. The questions that were put by the judges make interesting reading. So the judges were trying to ask the advocate who was appointed by the Prime Minister, because the Attorney General was not supporting the government, there was a private lawyer defending the government. So the questions that they were asking the lawyer appearing for the government were exactly the same questions which were put to the Attorney General of India when Keshwananda Bharati was being heard, or Minerva Mills was being heard, or Vaman Rao was being heard, as to what would happen to the citizens. You do not want somebody or some organ to become so powerful where the balance would not be there. We do not have separation of powers in this country. Separation of powers is only spoken of in judgments. You have 3 wings, each of them trying to take over the other. There is the The parliament wants to make laws and then say that court should not interfere. And court would be saying that this parliamentary legislation is not correct. Parliament doesn't like it. Executive decisions are interfered with by the court day in and out. Executive doesn't like it. Passes an order, court says stay. So they would say that how is it that we can run the government? I'll tell you an interesting incident without mentioning names. Before I became a judge, I was a law officer in both the governments, Congress and BJP. I was an additional Solicitor General. So one law minister who was a seasoned lawyer earlier, very seasoned lawyer, one of the stalwarts practicing now. He was a law minister, and then the right of privacy case was going on. The Aadhaar card case just started. I was asked to defend the government of India. I went and told him the judges are putting such inconvenient questions. What do we do? For a marriage registration, it seems Aadhaar card is being required to be shown in Bombay. This is about 10 years back, not now. All of you got used to all these Aadhaar cards now. Those days, people were agitated as to why Aadhaar for everything. So I was told by the law minister that what do the judges think of themselves? We are running the government. We know the difficulties of people. We are all elected by the people. Why should they start interfering with this? The same person who was a lawyer earlier, a lawyer now. So when you are there in the parliament, your perspective changes. When you are in the executive, you think otherwise. So when parliament makes legislations, what it does is, it definitely carries out the wishes of the people. In the United States of America, there is a principle called a counter-majoritarian difficulty. Alexander Hamilton wrote a book, The Least Dangerous Branch. He said that the least dangerous branch in the government is the judiciary, because it neither has the purse nor the sword. Purse means it doesn't have the money. For the money to run courts, judiciary has to depend upon the executive. Ultimately, money is sent by the government for the High Court to run here, and the salaries are paid by the government. It doesn't have fund on its own. It doesn't have the sword also, which means it passes an order, it passes a judgment which has to be implemented by, again, the executive. If the executive says, I am not going to implement, again, contempt powers, etc. are there, but the judiciary doesn't have policemen, or judiciary doesn't have army for implementation of its orders. That's the reason why Alexander Hamilton said that this is the least dangerous branch. But when the US Supreme Court started interfering in legislations from 1905 to 1930, in most of the legislations on grounds of judicial review and the due process clause, which we don't have in India, there started some sort of a philosophy which is called this counter-majoritarian difficulty. Questions started asking, who are you? The questions to the judges is, you are not elected. You are just sitting here and then saying that the parliament is wrong. Parliament is represented, they are representing people. They know what they want. So you do not have the right to say parliament is wrong. You should defer to the wishes of the parliament. 9 judges sitting in the US Supreme Court, they can't say that the legislation is wrong on due process. So this is one theory there. Now, I come to the final portion of revisiting the basic features. All these years, people were not talking about basic structure. All of a sudden, there's a debate on basic structure for the past 1 year. How has it all this started? We have some constitutional functionaries, I am again not going to refer to them, who started saying Keshwanand Bharati is wrong. So some judges started defending, some legal professionals also started defending, saying, oh, what is wrong with this? So everything is all right for these years, 73 onwards till 2023, everything was going on smoothly, government was also happy. So suddenly, why this debate? The debate is because, again, the parliament wants to make some laws, take them out of the reach of the court. Again, revisit the debate that was there about 50 years back, because it's 50 years after Keshwanand Bharati was decided by the Supreme Court. The problem in this country, as I see, constitutional functionaries do not stay within their limitations. We have speakers, after becoming speakers, towing the line of political parties. Day in and out, you might be seeing the speakers speaking on behalf of the ruling party, making comments in favor of the ruling party. There are no more independent. You have governors who have also been exceeding their briefs. I'll tell you about one case which I decided. This is the Rajiv Gandhi assassination case. A bail filed by a person by name Perarivalan came before me. He has been in jail for 39 years. And he has got 7 degrees when he was in jail. The state of Tamil Nadu wanted to release him by exercising power that is conferred on them under Article 162 of the Constitution. The governor doesn't want to decide. The position of a governor in the Constitution is he is head of the executive of the state. He doesn't have an independent view except for when he exercises powers as a chancellor of a university and other functions like that. 2 years he sat on the file. Perarivalan continued to be in jail. When the writ petition came up before me, I gave a long rope to the union government. The state of Tamil Nadu was saying that we have done our bit, but the governor is not passing an order. So I called the law officer and then told the Solicitor General, you better tell the governor to pass an order, otherwise we are going to give a direction. The problem of giving a direction to the governor is governor has an immunity, president and governor. But still, we have ways and means of getting an order passed and then directing the office of the governor through the state government to act. That's a judgment of the Supreme Court in Rameshwar Prasad. So with great difficulty, we made the governor take a decision. And what is the decision that he took? After 2 years, the decision taken by the governor is that I will refer this matter to the Union of India. The Union of India will now decide. A decision taken by the state government for which either he has to give approval, not either, he has to give approval. He says, now I'll send it to the Union of India, let them. It's very easy. So if I have to take a decision, I can escape by saying, this is called passing the buck. So the file goes to the next table. I need not take a decision. And we had to take an extraordinary step. Normal course, we won't do it. But under Article 142, a power that is given only to the Supreme Court of India under the Constitution to pass orders to do complete justice, I thought it is high time that he comes out. So that's the reason why we released Perarivalan, and after Perarivalan release, the other accused also have come out. Law is the same for everybody. Whether you are the chief minister, whether you are the prime minister, and whether you are a person who are a laborer, when you are talking about that equality, which means equal protection of laws, applicable of laws to a person. Merely because you are accused of a grave offense, it doesn't mean that you are not going to get protection of laws. So speaking of liberty, liberty is applicable to every person. So there cannot be any discrimination, at least by the courts. So when the court is exercising powers like this, you look at such instances where constitutional functionaries also go overboard. I would not shudder to say that even people from my tribe who are retired judges, they also overshoot. They also start getting into a debate. They also start criticizing their own people. All these things are not desirable. One thing that all of us have to remember, especially from the legal profession, is we should protect our judges. There is nobody to protect them. They cannot even speak out. At the same time, if at all there is an erring judge, you should be the first one to raise your voice and bring it to the notice of whoever the authority is. I'm not saying you should suffer anybody. You must be facing a number of persons who are unreasonable. Unreasonableness is not a ground to say that he has been misbehaving. But if at all he is crossing a line, definitely you should take it to the notice of whoever is in charge. The level of debate as it has come down in the political sphere is coming down in public life as well. So when you have people who just want to raise some issue by holding constitutional positions, that's how the situation which has arisen now about, oh, is it required that we should revisit the basic structure? For what reason? What has happened to this country? Is there anything wrong that has happened suddenly where you say that Keshwanand Bharati is wrong? The Chief Justice of India recently said Keshwanand Bharati is a North Star of Indian Constitution. I agree with him. We are what we are today, still enjoying this democracy only because the parliament is in check, only because the executive power is in check, and who's doing it? It is the court. I'm not saying court is supreme. There is no organ which is supreme in this country. It is only the constitution which is supreme. So this war cry of politicians saying parliamentary supremacy, according to me, definitely is not correct. All of us have a duty to imbibe the constitution, to protect the rights of citizens of this country. As legal professionals, we have an extra duty, and I'm sure that AILU will continue the endeavors which it is doing now by having seminars like this. You're going to have Justice Muralidhar, who is an extraordinary judge, who is going to address you in the afternoon. Justice Rajni is going to speak to you in the afternoon. I'm sure that all of you would enjoy listening to them. I'm also sure that I've shared my ideas, and some of them are interesting also to you. And I hope I have been able to communicate myself well. Thank you so much for the patient hearing.
It gives me an immense pleasure to thank Sri Lau Nageshwarao Garu, because the object basing on which we thought of organizing this seminar is fulfilled. And I hope that everyone in this hall has understood, and all of us should understood, that it is the only lawyer who can be a torchbearer of the society, and it is the preamble of the constitution which is leading all of us. So an immense duty is also cast on the advocate community to see that the rights of the public are to be protected, for which our services are needed more. I thank Sri Justice Lau Nageshwarao Garu, and the example which he has referred, the recent Israel example, is also to be kept in our minds, that in future there may be such type of situations, those may arise in our country also. So let us be alert. That is the caution that has been given by our speaker today. So I, and on behalf of all India Lawyers in Telangana committee and all the audience of the hall, I thank Sri Justice Lau Nageshwarao Garu for giving an extraordinary and outspoken opinion of him with regard to need of protecting the constitution. And I hope that we have not given trouble to him for calling from the Delhi. Yesterday night his flight was cancelled, and today morning he has taken risk of coming to Hyderabad by catching the flight at about 7 o'clock, and he reached on time to this seminar. And now I request Sri Justice Lau Nageshwarao Garu to release a book which is written by Sri Justice H.N. Nagamohan Das Garu, former Judge High Court of Karnataka, basing on the working of constitution, which was written in English. Now it is being translated version of Telugu is being to be released by Sri Justice Lau Nageshwarao Garu. And I am supposed to, or I am duty bound to say that Justice H.N. Nagamohan Das Garu has printed 1 lakh books of on the constitution, working of constitution, and he has addressed 10,000 of meetings basing on this working of constitution, and requested the people to save the constitution. So today we are fortunate that Sri Lau Nageshwarao Garu releasing the Telugu version of working of our constitution.
స్మాల్ అనౌన్స్మెంట్ ఏంటంటే ఈ బుక్ ఖరీదు 100 రూపాయలు, ఈరోజు 50 రూపీస్కి కొనుక్కున్న వాళ్ళందరికీ ఇవ్వబడుతుంది. కాబట్టి అందరూ కొనుక్కొని చదివి సర్క్యులేట్ చేయమని విజ్ఞప్తి చేస్తున్నాను.
One more assignment, sir. On the eve of, please. On the eve of this seminar, AILU Telangana Committee has conducted an essay writing competition to the law students, and we have chosen 9 law students who have written the essay, which is befitting to the today's topic of the seminar. And I request the organizer, Nisa Fatima, to come and read out the names of the winners of the essay writing. Nisa Fatima, please come. And I request Sri Lau Nageshwara Garu to present the small prizes to the winners.
I would like to explain, like, there are few of the essays which have been selected. So those selected essay candidates have been here for the distribution of the certificates from our chief guest. So the first one is Apurva. If she can come on the dais to collect her certificate. The second is Sonia. Yeah, Sonia. Shamshita. Shailaja. Bushra. I am Bushra Fatima.
Fortunately, this competition was conducted among all the students, but only lady students are more enthusiastic, and they have. That's what our chief guest is also asking, whether this competition is meant for only lady students.
Shahana.
And I request Fatima also to receive.
Yeah,
Sir.
sir.
Okay, thank you.
Thank you so much.
I request Sri D. Praveen to come and offer a vote of thanks. And before that, I request our Secretary Parthasarthi Garu to and M.V. Durga Prasad Garu to come on to the dais to present a small, it's not a memento, these are books we are presenting to the chief guest and also the guest of honor. And I request Durga Prasad Garu to present another not memento books to the other guests, Sri Narasimha Reddy Garu also. Vote of thanks by Mr. B. D. Praveen.
Respected guest of the seminar, Sri Justice L. Nageshwar Rao Garu, before elevation to the Supreme Court, Nageshwar Rao sir is the founder, president of AICA, that is All India Advocates, High Court Advocates Association. I am also been part of the AICA from AP High Court. Sir, your keynote on revisiting basic structure of Constitution gives us immense aspiration to strengthen the democracy, socialism, secularism, and justice. I, on behalf of Telangana State Committee, All India Lawyers Union, we thanks to Sri Justice L. Nageshwar Rao Garu, and also I thank our President Koli Satyanarayana Garu, and also thank our General Secretary Sri K. Patar Sarthi Garu, and also I thank all the organizers and A. Narasimha Reddy Garu. He is our eldest brother since from 2005 onwards. He is associated with the AILU, and also I thank all dear participant, students, media, and also fraternity from all District Bar Association advocates. Thanks one and all.
మిత్రులారా, ఈ లంచ్ ఇప్పుడు ఉంది పైన థర్డ్ ఫ్లోర్లో. అందరూ భోంచేసి వచ్చి మళ్ళీ ఇక్కడే కూర్చోవాలి, ఎందుకంటే సెషన్ స్టార్ట్ చేయబోతున్నాం.
కలలు కన్నా సమాజపు నేత్రమా, మనుషులందరూ ఒక్కటేనని చాటినావు మహాత్మా. జ్యోతిబా పూలే జోహారు జోహారు, మా జాతికే వెలుగు దీపమైనారు. మా బడుగులకు మీరు బాపు అయినారు. సమత మమతలు పంచి జనుల హితము కోరిన గౌతమా, కులము మతముల మరచి బడుగులనొకటి చేసిన గౌతమా. ఎవడు అధికుడు ఎవడు అధముడు ఎవడు చేసిన ధర్మమిది అని బహుజనులను కూడదీసి భారతీయతనొకటి చేసి అక్షరాలను నేర్పి ప్రజలను ఆయుధాలుగా మరచినావు. అక్షరాలను నేర్పి ప్రజలను ఆయుధాలుగా మలచినావు. జ్ఞానమును పెంచే సుజ్ఞానివై నువ్వు నిలచినావు. జ్యోతిబా పూలే జోహారు జోహారు, మా జాతికే వెలుగు దీపమైనారు. మా బడుగులకు వెలుగు దీపమైనారు. మనువు నీవు మాకు చూపి మూలవాసుల గొంతు నులిమి, దళితులు రవతలుంచి రాజ్యమును మీరనుభవించి, ఎంతకాలం ఈ వివక్షని ఎదురు తిరిగిన యోధుడా, ఎంతకాలం ఈ వివక్షని ఎదురు తిరిగిన యోధుడా. ప్రేమ జాలి త్యాగ కరుణం కలిపి నడిపిన బుద్ధుడా. జ్యోతిబా పూలే జోహారు జోహారు, మా జాతికే వెలుగు దీపమైనారు. మా బడుగులకు మీరు బాపువైనారు. రంగురంగుల ఇంద్రధనసు వంగిపోవుట సత్యము, నింగిలోని నిగనిగలకు నీలి రంగే నిత్యము. మార్పు కోరిన సూర్యుడా మార్పు కోరిన సూర్యుడా, ఇక తూర్పు దిక్కే మాకురా. మార్పు కోరిన సూర్యుడా, ఇక తూర్పు దిక్కే మాదిరా. బడుగులకు బలహీనులకు ఆరాధ్య దైవం నీవురా. జ్యోతిబా పూలే జోహారు జోహారు, మా జాతికే వెలుగు దీపమైనారు. మా బడుగులకు మీరు బాపువైనారు. సమత మమతలు పంచి జనుల హితము కోరిన గౌతమా, కులము మతముల మరిచి బడుగులనొకటి చేసిన గౌతమా. సమత మమతలు పంచి జనుల హితము కోరిన గౌతమా, కులము మతముల మరిచి బడుగులనొకటి చేసిన గౌతమా.
Kalyani from Khammam, sing a song.
Thank you, sir, given this opportunity.
మౌనంగానే ఎదగమని మొక్క నీకు చెబుతుంది, ఎదిగిన కొద్దీ వదగమని
అర్ధమందులో ఉంది. మౌనంగానే ఎదగమని మొక్క నీకు చెబుతుంది, ఎదిగిన కొద్దీ వదగమని అర్ధమందులో ఉంది. అపజయాలు కలిగిన చోటే గెలుపు పిలుపు వినిపిస్తుంది, ఆకులన్నీ రాలిన చోటే కొత్త చిగురు కనిపిస్తుంది. మౌనంగానే ఎదగమని మొక్క నీకు చెబుతుంది, ఎదిగిన కొద్దీ వదగమని అర్ధమందులో ఉంది. దూరమెంత ఉందని దిగులు పడకునేస్తమా, దరికి చేర్చు దారులు కూడా ఉన్నాయిగా. భారమెంత ఉందని బాధపడకునేస్తమా, బాధ వెంట నవ్వుల పంట ఉంటుందిగా. సాగర మదనం మొదలవగానే విషమే వచ్చింది, విసిగే చెందక కృషి చేస్తేనే అమృతమిచ్చింది. అవరోధాల దీవుల్లో ఆనంద నిధి ఉన్నది, కష్టాల వారధి దాటిన వారికి సొంతమవుతుంది. తెలుసుకుంటే సత్యమిది, తలుచుకుంటే సాధ్యమది. మౌనంగానే ఎదగమని మొక్క నీకు చెబుతుంది, ఎదిగిన కొద్దీ వదగమని అర్ధమందులో ఉంది. చెమట నీరు చిందగా నుదిటి రాత మార్చుకో, మార్చలేనిదేదీ లేదని గుర్తుంచుకో. పిడికిలే బిగించగా చేతగీత మార్చుకో, మారిపోని కదలే లేవని గమనించుకో. తోచినట్టుగా అందరి రాతను బ్రహ్మే రాస్తాడు, నచ్చినట్టుగా నీ తల రాతని నువ్వే రాయాలి. నీ ధైర్యాన్ని దర్శించి దైవాలే తలదించగా, నీ అడుగుల్లో గుడి కట్టి స్వర్గాలే తరించగా, నీ సంకల్పానికి ఆ విధి సైతం చేతులెత్తాలి. అంతులేని చరితలకి ఆది నువ్వు కావాలి. మౌనంగానే ఎదగమని మొక్క నీకు చెబుతుంది, ఎదిగిన కొద్దీ వదగమని అర్ధమందులో ఉంది. అపజయాలు కలిగిన చోటే గెలుపు పిలుపు వినిపిస్తుంది, ఆకులన్నీ రాలిన చోటే కొత్త చిగురు వినిపిస్తుంది. మౌనంగానే ఎదగమని మొక్క నీకు చెబుతుంది, ఎదిగిన కొద్దీ వదగమని అర్ధమందులో ఉంది.
మేడం దీని తర్వాత సూర్యుడే సెలవని అలసిపోయేనా, కాలమే శిలవలే నిలిచిపోయేనా, మనిషి మనిషిని కలిపిన ఓ ఋషి, భూమిని చరితను నిలిపెను నీ కృషి.
మహాశయా విధి పగై తరిమెరా, మహోష్ణమై రుధిరమే మరిగెనా,
ఆగిపోయేనా త్యాగం కథ ఆదమరిచేనా దైవం వృధా సూర్యుడే సెలవని అలసిపోయేనా కాలమే శిలవలే నిలిచిపోయేనా
అది సాడ్ సాంగ్ అంట కదా.
తెలుసు మీ కాళ్ళు ఉన్నాయని, మీ కాళ్ళు ఉన్నాయని తెలుసు. మీదే కదా ఫోన్.
హలో, ఎవరు రాయగలరు, ఎవరు రాయగలరు అమ్మాను మాట కన్న కమ్మని కావ్యం, ఎవరు పాడగలరు, జాయిన్ అవ్వండి ఈ పాటలు, ఎవరు రాయగలరు అమ్మాను మాట కన్న కమ్మని కావ్యం, ఎవరు పాడగలరు అమ్మాను రాగం కన్న తీయని రాగం, అవతారమూర్తి అయినా అనువంతే పుడతాడు, అమ్మ ప్రేగు పంచుకొని అంతవాడు అవుతాడు, అవతారమూర్తైన అనువంతే పుడతాడు, అమ్మ ప్రేగు పంచుకొని అంతవాడు అవుతాడు, అమ్మేగా అమ్మేగా చిరునామా ఎంతటి ఘన చరితకి, అమ్మేగా కనగలదు అంత గొప్ప అమ్మని, ఎవరు రాయగలరు అమ్మాను రాగం కన్న తీయని రాగం. థ్యాంక్ యూ. నన్ను దోచుకుందువటే, నన్ను దోచుకుందువటే వల్లెల దొరసానే,
కన్నులలో దాచుకుందు నిన్నే నా స్వా
ఎంతటి నిరజానవో నా అంతరంగమందు నీవు, ఎంతటి నిరజానవో నా అంతరంగమందు నీవు, కలకాలం వీడని సంఖ్యలలు వేసినావు, సంఖ్యలలు వేసినావు. నన్ను దోచుకొందువటే, నన్ను దోచుకొందువటే వన్నెల దొరసాని.
కన్నులలో దాచుకొందు నిన్నే నా స్వామి, నిన్నే నా స్వామి.
నన్ను దోచుకొందువటే.
నా మదియే మందిరమై నీవే ఒక దేవతవై, నా మదియే మందిరమై నీవే ఒక దేవతవై, వెలసినావు నాలో నే కలసిపోదు నీలో, కలసిపోదు నీలో.
ఏ నాటిదో మన బంధం ఎరుగరాని అనుబంధం, ఏ నాటిదో మన బంధం ఎరుగరాని అనుబంధం. ఎన్ని యుగాలైనా ఇది ఎగిరిపోని గంధం, ఎగిరిపోని గంధం. నన్ను దోచుకొందువటే, నన్ను దోచుకొందువటే వన్నెల దొరసాని.
కన్నులలో దాచుకొందు నిన్నే నా స్వామి, నిన్నే నా స్వామి.
నన్ను దోచుకొందువటే.
థ్యాంక్ యూ, థ్యాంక్ యూ.
ఫ్రెండ్స్, రాజ్యాంగాన్ని కాపాడుకోవాలనే దీని మీద ఒక పాట సుద్దాల అశోక్ తేజ గారిని అడిగాము. మా ఇబ్బంది వల్ల ఆయన మేము కలవలేకపోయాము. కానీ ఒక షార్ట్ ఫిలిం కూడా తీయాలని అనుకున్నాము. ఆ షార్ట్ ఫిలిం కూడా తీస్తాము, పాటలు కూడా తయారు చేస్తాము. ఈ రాజ్యాంగాన్ని ముందుకు ప్రజల్లోకి తీసుకెళ్ళటానికి ప్రయత్నం చేస్తాం. ఇప్పుడు రెండో సెషన్ ఇంకొక 5-10 నిమిషాల్లో స్టార్ట్ అవ్వబోతుంది. వచ్చారు గెస్టులు, వాళ్ళు కూడా వచ్చేసారు కాబట్టి ఇక స్టార్ట్ అవుతుంది. ఇప్పుడు తర్వాత నెక్స్ట్ సెకండ్ స్టార్ట్ పోబోతుంది. అందరూ ఎవరైనా టీ తాగాలని అనిపిస్తే వెనక ఉంటుంది, అక్కడ పోయి తాగొచ్చు. కానీ లోపల హాల్లోకి మాత్రం టీ సప్లై చేయబడదు. అందుకని అదేదైనా ఉంటే డిస్టర్బెన్స్ లేకుండా పోయి తాగొచ్చు. అయితే 3 o'clockకి టీ కూడా సప్లై చేయబడుతుంది.
చిన్న ఆ చల్లని సముద్ర గర్భం దాచిన బడబానలమెంతో, ఆ చల్లని సముద్ర గర్భం దాచిన బడబానలమెంతో, ఆ నల్లని ఆకాశంలో కానరాని భాస్కరులెందరో, ఆ చల్లని సముద్ర గర్భం దాచిన బడబానలమెంతో. భూగోళం పుట్టుక కోసం రాలిన సురగోళాలెన్నో, ఈ మానవ రూపం కోసం జరిగిన పరిణామాలెన్నో. భూగోళం పుట్టుక కోసం రాలిన సురగోళాలెన్నో, ఈ మానవ రూపం కోసం జరిగిన పరిణామాలెన్నో. ఒక రాజును గెలిపించుటలో ఒరిగిన నరకంఠాలెన్నో, ఒక రాజును గెలిపించుటలో ఒరిగిన నరకంఠాలెన్నో. శ్రమజీవుల కత్తి నెత్తురును, శ్రమజీవుల పచ్చి నెత్తురును తాగని బలవంతులెందరో, శ్రమజీవుల పచ్చి నెత్తురును తాగని బలవంతులెందరో. ఆ చల్లని సముద్ర గర్భం దాచిన బడబానలమెంతో. అన్నార్థులు అనాథలుండని ఆనవయుగమదెంత దూరము, కరువంటూ కాటకమంటూ కనిపించని కాలాలెప్పుడో. అన్నార్థులు అనాథలుండని ఆనవయుగమదెంత దూరం, కరువంటూ కాటకమంటూ కనిపించని కాలాలెప్పుడో. అనగారిన అగ్ని పర్వతం కనిపించిన లావా ఎంతో, అనగారిన అగ్ని పర్వతం కనిపించిన లావా ఎంతో. ఆకలితో చచ్చే పేదల, ఆకలితో చచ్చే పేదల శోకంలో కోపం ఎంతో, ఆకలితో చచ్చే పేదల శోకంలో కోపం ఎంతో. ఆ చల్లని సముద్ర గర్భం దాచిన బడబానలమెంతో. పసిపాపల నిదుర కనులలో ముసిరిన భవితవ్యం ఎంతో, పసిపాపల ముసిరిన కనులలో ముసిరిన భవితవ్యం ఎంతో. రాయబడని కావ్యాలెన్నో పసిపాపల నిదుర కనులలో ముసిరిన భవితవ్యం ఎంతో. గాయపడిన కవి గుండెలలో రాయబడని కావ్యాలెన్నో, కులమతాల సుడిగుండాలకు బలి అయిన పవిత్రులెందరో, కులమతాల సుడిగుండాలకు బలి అయిన పవిత్రులెందరో. భరతావని బలపరాక్రమం చెరవీడేది ఇంకెన్నాళ్ళో, భరతావని పరకరాక్రమం చెరవీడేది ఇంకెన్నాళ్ళో. ఆ చల్లని సముద్ర గర్భం దాచిన బడబానలమెంతో. ఆ నల్లని ఆకాశంలో కానరాని భాస్కరులెందరో. ఆ చల్లని సముద్ర గర్భం దాచిన బడబానలమెంతో.
Good afternoon. All the advocates come into the hall. We are going to begin the second session today. All the advocates requested to come into the hall. Good afternoon, everybody. In this second session, I invite Sri Mr. M.V. Durga Prasad Garu, Advocate, High Court of Telangana, who will chair this session. I invite Sri John Bitters, Honorable Member of Parliament, Rajya Sabha. I invite Honorable Srimati Justice T. Rajani Garu, former Judge, High Court of AP and Telangana, Judicial Member, NCLT, Amaravati Bench, AP. I invite Sri Kolli Satyanarayana Garu, President of AILU, Telangana State, come and occupy the chair. I hand over the session to the Honorable Chairman.
Sorry for interruption, and I request Sri Akhil to come and offer a bouquet to Sri Britas. Both. We don't discriminate. And I request Shailaja CH to come and offer a bouquet to Srimati Rajani Garu. వెనక ముందు నుంచి రామ్మా. I request Sri D. Praveen Garu to offer bouquet to Sri M.V. Durga Prasad Garu. Thank you. Sir, please proceed.
Good afternoon, everybody. The speakers in the dais and my friends in the gallery. Today's topic for discussion is federalism in constitutional framework and present scenario. The speakers will be speaking on the federalism. The general question is India never had any federal state. It was unitary. All academicians will tell us that India is a weak or loose federation. It never had one nation. It is only the Britishers who have given. This kind of academic the analysis we find. But my feeling is India is never, it is never a unitary state, even during the British period. There are 567 native states in British India which were having their own culture, their own heritage, their own language or linguistic history. And there were very big states like Hyderabad state, Gwalior, Baroda, and many other states. And even in British India, if we see the history of the British India, the British, though then the East India Company conquered certain parts of the country, the Madras state, Bombay state, and Bengal state, and Punjab, these are the very big states. Of course, subsequently in 1930s, central provinces came into being. But these four states had different heritage, different background, different legal system, and the high courts that were operating in different parts of these native states applied principles of international law when some of the parties belong to are non-residents. They are not domiciled in that particular state. So therefore, it is not true to say that it was a unitary state. It is only under the constitution it is made federal, and therefore it is not true in true sense of federalism. It is not federal. And another thing is India is such a large country. Now we are the most populous country in the world, and India had different languages and major languages itself running into more than 20 now, which are recognized. And the part 11 of the Constitution tells us how there shall be an official language to the union, official language to every state, and there is an official language in which the center and states have to communicate, and whatever may be the official language, every person is entitled to make representation to the administration in his own language, and it must be considered. Apart from that, Article 30 says that it is equivalent, linguistic minority has got the same rights as religious minority in terms of they can, to protect their culture, education, they have education rights, they can run their own educational institutions. Now, in this background, the federalism or the federal structure that is given under the Constitution has to be understood. And India shall be union of states. It can never be a unitary state under the Constitution. But the most difficult part is the Parliament is given enormous powers under Article 3 and 4 to alter, to create, to make and unmake states. And therefore, that's the reason why everybody quote that you can't, you cannot say Indian Federation is a strong federation. It is only more an administrative federation, which in the context of language and linguistic rights, in the context of the different culture, apart from that, so far as the land laws are concerned, and a many number of laws, even some like in Kerala, there are some even religious legislations with regard to the succession. In spite of what I'm trying to say is, these different zones or parts of India had different legal system of their own. That is the reason why, though under the constitution we generally call judiciary is unitary in India, and they say the Supreme Court is the apex court and the high courts in the middle and the subordinate courts at the ground level. The district judiciary and other tribunals and the courts within the jurisdiction of every high court are subordinate, and the power, high court under Article 227 has power of superintendence over these courts and tribunals, which the Supreme Court has no such power. No such power is conferred on the Supreme Court. And High Court is not a subordinate court to Supreme Court. And though our constitution preferred the word union to federal under 1935 Act, and there is no expression like central government under the constitution. It is the government of India under the constitution. There is no expression central government in the constitution at all. It is a distortion. It is a distortion of the constitution. This is an expression which was used by many pre-independence legislations by the central legislature, which passed several acts. Under those acts, because at that particular point of time, the expression is central government and in contradistinction to states, the governors and the governor general. And under 1919 Act, Governor General in Council and the Governor in Council, they were made bicameral. Some kind of division of powers were made, which were under 1935 Act have given a concrete shape. In fact, most of the provisions under the Government of India Act are incorporated under our Constitution. And Article 245 to 258, practically most of the articles were borrowed from the 1935 Act. But there is an essential difference. The essential difference is, there is though not in terms of, not in the manner the American Constitution has made, there is no complete separation of powers. There is the power to decide whether a particular legislative or executive action is constitutional or not. We have under Article 13(2) any legislation, whether it is pre-constitutional or post-constitutional, which infringes the fundamental rights, is declared void. Who has to decide? It's the court under Article 32 and again under 226. Under 32, the Supreme Court has power only in respect of fundamental rights. It can issue directions, writs only for violation of the fundamental rights, but not any other purpose. though under Article 137, the Parliament has the power to confer extra powers to the Supreme Court also, so that has not been done. But under 226, the High Courts were given power not only to issue rights in case of violation of the fundamental rights and for any other purpose. Similarly, when it comes to so far as the judicial review is concerned of the legislative action, we have the 3 articles, 31A, B and C. In the morning, Justice Nageshwar Rao has covered them. And what I want to put before this, all of us, is to see the impending threats to the federalism. This, and every one of us are experiencing how the government of India is using certain agencies under its control like CBI, ED, EC. They have become such names. Nobody, even uneducated people in this country, are now aware of it. So in the context of these threats, which are distortions of it is nothing wrong with the Constitution. It is the working of the Constitution that is sought to be manipulated. And that is what we all have to explore, the ways and means of protecting our Constitution and federalism. Thank you. With this, I invite John Britas Garu to address.
I request all of you to go through the Telugadda YouTube, where this entire program is given live telecast, please.
Thank you, Mr. Durga Prasad. Justice T. Rajani also is in the panel, and the organizers have told me that I may take half an hour to express my views on this very pertinent issue. Most of those people who have been conversed here should be lawyers. Am I correct? All right. Since I am a parliamentarian and a politician, and moreover, a media person, I would be talking from my experience as I see the Indian Federation from the parliament, from outside, from my state, that is Kerala. Now the next session is going to be addressed by Justice Muralidhar. If the system were to be robust and meticulous, you would not have a speaker in the form of Justice Muralidhar till 2026 August. You know why? He would have been presiding over a bench in Supreme Court. Since he was not nominated to the Supreme Court, he has become a panelist of this national seminar. This manifests the issue that is plaguing the country or the nation now. Being a member of parliament, I would start from my experience of shifting to the new parliament building. Earlier you had a colonial parliament, that is what the present government dispensation says so. We have shifted to a nationalist parliament now. That is what is it. The nationalist parliament house more or less reflect the actual situation of the nation now. The parliament has been completely segregated. There is no central hall. Media is not permitted to the lobbies of the parliamentarians. Earlier, when Rajya Sabha used to adjourn, and Lok Sabha used to adjourn, we all used to converge at the central hall of the parliament. Now there is no meeting place, there is no convergence point. I think this is a true reflection of the country, the trajectory through which the country is passing. I've been asked to speak about federalism. It's true that when the framers of the Constitution finalized the document, they made it a quasi-federal country. Article 1 of the Indian Constitution says that India is a union of states. Nevertheless, it has been skewed in favor of the center. But I would just quote you what Jawaharlal Nehru said about the document. He defended the unitary slant of the Constitution, said so. I quote him, "It would be injurious to the interests of the country to provide a weak central authority which would be incapable of ensuring peace, of coordinating vital matters of common concern, and of speaking effectively for the whole country in the international sphere." So the unitary slant of the Constitution was based out of the apprehensions or fears of the framers of the Constitution. We should all think that it was in the aftermath of partition, and when most of the princely states were outside and were being rallied in. So there were, I would say, angst and apprehensions with regard to the unity of the country. Where will this India tread ahead? Nevertheless, there was B.R. Ambedkar who underlined the thoughts of the constitution makers. He said so, I quote, "The Constitution is a federal constitution. The Union is not a league of states, nor are the states the agencies of Union deriving powers from it. Both the Union and the states are created by the Constitution. Both derive their respective authority from the Constitution." This is what B.R. Ambedkar said. Now, what is the state of affairs of the country? Durga Prasad ji, you are kind enough to say or give some hints with regard to the teething problems this nation is facing. I would say that the trend in this country is completely, inverted comma, concentration of power. Justice, please bear with me when I say that it's one nation, one ideology, one culture, one language, one leader. That is what is the motto which is being prevalent in this political juncture. I have no hesitation. I'm a politician. I should say. I would not be mincing my words when I say so. Now, G20. You know what was the tagline of G20? It was a so huge fanfare in the country. Was there a program in Hyderabad also? I presume so. The tagline of G20 was 3 Ds: development, democracy, and diversity. This was the tagline of G20. But when I look at the politics, when I look at the political situation that is emerging, the 3 Ds that are prevalent in this country, one is destabilize, second is disrupt, and third is defame. What does it mean? If you have an opposition government in a state, the first D comes into operation. That is, destabilize it. Am I not correct? Are you all sleepy? I don't know. It's a very difficult time to address people after this lunch. half a dozen state governments have been brought down. The MLAs have been purchased. It's not the assembly or the parliament which became the sanctum of democracy, but certain resorts. And if you cannot destabilize a government, what you do? You need to disrupt it. How do you disrupt it? You have numerous ways of disruption. In Kerala, we see the disruption in the form of the role of the governor. I presume that Telangana also must be having, inverted comma, not the governor general. You need to rename the governors as governor generals now, actually. They are more powerful, or rather, they seem to be more powerful than an elected government. Now, if you cannot disrupt an opposition-led government, then the third thing is defame. The Prime Minister of this country had the audacity to be a brand ambassador of a movie called Kerala Story, which was produced just to defame a state called Kerala. Kerala was depicted as a state being the hotbed of terrorism, but the statistics of the central government would vouch for the fact that Kerala is the most peaceful state in the country. Just see the 3D in operation. You know, if you compare this, I'm standing in, in South India, this citadel of South India. I was having a debate in Parliament and I was saying, unity and integration. Home Minister looks after the integration of this country, unity of this country. He came to Karnataka on a campaign, which he lost miserably. That's another thing. And he was saying, voters of Karnataka should beware, because you have a neighbor called Kerala. Can you ever imagine a Home Minister of this country saying that? You should be afraid of a state called Kerala. The Home Minister should have said, you should be glad to have a state like Kerala as your neighbor. I wrote an article in Indian Express. This is completely unbecoming of a Home Minister. He should not be instrumental in defaming a state, because he is the custodian of the federalism. After a couple of weeks, I was served a notice by the Rajya Sabha chairman, that is the Honorable Vice President. I was called in to give an explanation, because the complaint which was lodged against me said that action should be taken against John Brittas because he is indulging in sedition. Durga Prasad ji, you are making so much of money in civil matters, but do you know the criminal matters? I came to know that he is a very affluent lawyer. But his goodwill is there because he argues many cases on pro bono basis. So, congratulations, sir. Can you imagine a member of parliament being called upon to explain to a complaint that if I try to protect my home state, I am charged with sedition? Sir, the 3 Ds have become, as I said, destabilize, disrupt, defame. You know what is the tagline of, I think it is Washington Post or New York Times? That is also 3 Ds. Democracy dies in darkness. Democracy dies in darkness. I am very glad that the preamble of the Constitution has been enshrined in this leaflet. But sir, we solemnly assure the citizens justice, social, economic and political. So what is the justice now? I just talked about the justice that is being imparted now in many of the states now. The justice is being in the form of bulldozers in many states. Sir, liberty of thought, expression, belief, faith and worship. Liberty of thought. The underlying aspect of a democracy is a free media. You may have an executive, you may have a judiciary, you may have a legislature. Even the Arab nations have so. Unless a nation has a free media, it can't be a true democracy. Please trust me. Can anybody claim that India does have a free media now? Absolutely no. It is completely caved in. That's why a lawyer friend of mine who was a journalist there, where is Arjun Kambe? Where are you, man? He calls all the media guys Godi media, Godi media. His colleague Veeray also is here. A gentleman editor, during the second wave of COVID, when crores of people were left on the roads, from Kerala, lakhs of people had to go to their own homeland in UP. No transportation. You know, a movie has been made when people had been ran over by a train in Aurangabad when they were sleeping on the sleepers, on the train tracks, because it was forest. The government had completely abandoned the crores of people. Then a magazine called Outlook put out a cover story saying that missing, India government missing. Madam, you would be surprised. After 3 weeks, the editor of the magazine was sacked. The editor of the magazine was sacked. There was only one newspaper in this country which gave a photograph of the floating dead bodies in river Ganges during the second wave. Only one newspaper. You know these newspapers and television in the debates, Muslim, Hindu, Muslim, Hindu. Have you ever seen a newspaper or a television giving the photograph of those hundreds of bodies which were seen floating in the river Ganges? One newspaper gave, Dainik Bhaskar. The following day, CBI, Income Tax, Enforcement Directorate raided the newspaper office. Khatam ho gaya. Finished. Yesterday night, a order was issued by Anandabazar Patrika, which operates the Telegraph newspaper, which was the last post of hope, of resistance. The editor has been removed because he was bold enough to give stories against the establishment, Delhi establishment. So what to infer from that? If you don't have a free media, how does democracy survive? And I don't need to talk about judiciary because in my initial remarks I said that you people are lucky to have Justice Muralidharan because we don't have a transparent appointment system in the Supreme Court or in high courts. A judge with impeccable integrity, matchless probity, was not promoted to the Supreme Court. In my maiden speech in Rajya Sabha, I reminded the judiciary about the lack of diversity. Sirs, the underlying factor for a federalism is to have a democratic setup now. Without democracy, how can you even envisage a federalism? When you talk about democracy, you need to have representation. There is something called vertical representation and horizontal representation. Now, the whole gamut of issues which are being discussed under federalism comes under the vertical aspect which I need to dwell on. When you talk about horizontal representation, I feel this is the only one country which tread ahead without giving representation to the people. 20 crores of the population in this country are not represented in the executive. You know what I am trying to say. 20 crores Muslims in this country do not even have a representation in the union government. I was just looking at the first cabinet of Nehru. Maulana Azad, Rafiq Kidwai, Ambedkar, Jagajeevan Ram. Who else? See the model government. From there, how we have drifted, how we have reached this level. I will take few more minutes because you need to listen to the erudite presentation of Justice Rajani. Nevertheless, I will have to talk about the political aspect of the federalism. I said about how the governors become governor generals. Now the Damocles sword is actually hanging on the southern states. The delimitation is going to come. When the delimitation comes, what is going to happen is that the representation of the southern states in Lok Sabha and Rajya Sabha will come down, or rather would be static. You know why? The slogan now is that perform and perish. Earlier the slogan was perform and you be rewarded. Now the slogan is that you perform and perish. Because we control the population, we are going to be penalized. We are going to be penalized. Now, think about the economic aspect of the federalism. You know, state of Kerala contributes 1 rupee to the national kitty and gets back 25 paise. This could be the, I would say even Telangana also. Southern states bear the brunt for its performance. Earlier you had planning commission, you had guided formula. Now the government of India is using surcharge and duty to mop up resources. I asked a question in Rajya Sabha. What could be the quantum of money you must have mopped up through surcharge and duty? You know what is the catch in surcharge and duty, sir? You don't need to divide among the states. It's not divisive. So what does the government do? The government doesn't raise the GST, doesn't raise the corporate tax, doesn't change the slab of the income tax. They impose duties and surcharge so that you don't need to divide these resources amongst the states. The reply to my question, the government said, last year alone, they mopped up 7 lakh crore. 7 lakh crore on duty and surcharge. So during the COVID, you all got the certificate. What was the certificate? You have a COVID certificate, sir? Government certificate? You have a smiley Modi, yeah, that's correct. Modi always smiles, sir. And the government was saying we spent 33,000 crore for free vaccination. Madam, didn't this government say? You must have heard about that. Didn't you hear that? You know what is the cash there? 33,000 crores was spent on vaccination, and the government, through health surcharge, mopped up 53,000 crores. What a businessman he is. Spending 33,000 crores, mopping up 53,000 crores. I asked a question, then it came out. Earlier, surcharge used to be for a short period, just for an exigency. Not now. Surcharge continues. They say that they give you so much of money to the states for education. Please understand, that is out of the surcharge which you give. And they make the schemes and send it to us. We cannot match these schemes. You know why? We have surpassed the threshold. So the government of India last year announced PM Sri schools. You know what is PM Sri schools? Having a PM Sri school in every village which doesn't have a school. Kerala government is groping in the dark. Where to find a village which doesn't have a school? We all have. So your money, my money is being siphoned out to other states because we performed. That is what I said, perform and perish. So is this the federalism that was ushered in by Ambedkar? Didn't he say so? Didn't he say so? We are equal partners of this constitution. We are not an agency of the center. Didn't he say so? Madam, let me just tell you one thing. The Supreme Court fudged very badly. Often they do, you know that. They made a sweeping remark saying that the Parliament has the fundamental right to change a state to a union territory. Can you ever imagine? In the context of the abolition of 370 of Jammu and Kashmir, a case came up in Supreme Court and the judges said that the government has every right if the Parliament passes. It simply means that the state of Telangana tomorrow can be converted as a union territory and Amit Shah will come and rule the state. Will you allow, sir? Will you allow, sir? Do you want Amit Shah to come down and rule the state? He says even now it is like that. I don't know what it is. Now, there is an onslaught against the basic structure of the Constitution. The situation is such as even a gentleman judge who presides over the Supreme Court is a colleague of mine in Rajya Sabha now. You know whom I am referring to. He passed 2 judgments in Supreme Courts upholding the validity of the basic structure. The same gentleman, after becoming a member of parliament in Rajya Sabha, he opened his mouth for the first time and he said that basic structure is not sacrosanct. Is this the integrity of the judiciary? Is this the judiciary we are looking up to? Is the judiciary which is supposed to be the custodian to protect the constitution of this country? He is playing a different role. Sir, everybody is playing a different role, sir, now. So, political onslaught against the federalism. I told about economic onslaught. Nowadays, there is nothing called. See, from planning commission to election commission, the institutions are being completely devastated. Every institution that was built up in this country has been either done away with or being abandoned or systematically destabilized. When we talk about federal economy, now you see a prime minister going to an election-bound state and declaring bounty for the state, 20,000 crores, 30,000 crores, 50,000 crores. Kiska paisa hai? Hamara paisa hai. Sir, this is a country where there used to be a formula to divide the resource of this nation. Now there is no formula. Now, another cardinal principle, I talked about the culture. Durga Prasadi was very benevolent when he talked about the number of languages. Couple of months back, I was in Manipur, and I could see that. See, when we talk about Manipur, it's also part of the federation actually. But that's one state among 28 states which has been completely abandoned by the government of India. The Prime Minister doesn't think there is a state called Manipur now. And it has been burning for last 5 months. Can you ever imagine a state of the nation is burning continuously for 5 months consecutively? There are 300 ethnic groups there. Why did we choose a federation? It's such a rich, diverse nation with hundreds of languages, moorings, your own style. But now you can see the imposition of a language over this country, Hindi. Hindi is the language. See, I was surprised to read the speech of Annadurai, the great Dravidian patriarch. Annadurai was a member of Rajya Sabha in 1960s. I dug up a couple of his speeches. You'd be surprised. You know what he talks? He talks about self-determination. He said it is the right of the southern states to determine our future. He said so. Tomorrow I should not be castigated as an anti-national. Okay, I am quoting Annadurai. 1962 April, Annadurai spoke in Rajya Sabha. And he even said that we cannot bear with the imperialism of the North. He even talked about the language. And he was saying that, more or less inverted comma, may not be correct. If my quote goes wrong, just take the sum and substance only. He says, I am seeing few members who can very well speak in English. They deliberately ask the question in Hindi. And the minister who can speak in English deliberates the answer the question Hindi. and you have a star in your eye. This is not the way you need to conduct yourself. You shouldn't impose Hindi over us. That's what Annadure said. Sirs, I covered the Indian Parliament from 1988 onwards. At that time, when I used to cover the Parliament as a journalist, 90% of the discourse in the Parliament was through English language. Now not even 5% in English. Only 2 ministers of this cabinet have the right to speak in English. All other ministers, whether they know English or any other language, they are supposed to speak in Hindi alone. I have seen Kiran Rijiju, the former law minister, sometimes he starts in English. Suddenly somebody will prompt him, Hindi. He would just turn to him. Is this the federal spirit that was been co-opted by the Indian Constitution? Absolutely no, sir. So I would say that India has traveled a lot away from the cardinal principles enshrined in the Constitution. And I would say that 2024 election is going to be very crucial. If the delimitation happens, already the South India, I have no hesitation in saying so, already South India is an informal colony. If delimitation happens, it would be a formal colony. Madam, the G20 was talking about global South. Global South. Shouldn't the government talk about the South India? That's more important. I would say that India, being a rich, diverse country, unless you can protect the diversity of this nation, the unity of this nation cannot be protected. Diversity is the strength of this nation. And the administrative, political form of diversity is federalism. And some of my friends have a misconception saying that when I always talk about democracy in danger, some of them say that, Britas, don't worry about that. We have a constitution which will protect Indian democracy. Humbug. Only democracy can protect this constitution. Please understand. Unless you have a democracy, this constitution cannot be protected. So the underlying aspect of federalism, constitution, independent judiciary, everything relies on democracy. If you can't protect democracy, everything which are supposed with superstructures would get demolished. I wish that such deliberations like this would enrich the discourse in our society so that the people of this country have a clear perspective about what our constitutional makers, the framers of this constitution and the founders of this nation had envisaged with regard to the federal structure of this nation. Thank you very much.
Thank you, Mr. Das. The most, your emphasis, we have been taught and made to believe that it is the judiciary that protects the Constitution. It is the custodian of the Constitution. But you have very well said, it is the democracy which will protect the Constitution and its organs. And now I invite Justice Rajani Garu to come to the dais and speak.
It's an honor to be invited to talk to you all on a topic like federalism, which I think is highly contemporaneous, more for the challenges that it is facing in the present times. I also would like to remark that for the same reason for which Justice Muralidharan could not have been invited till 2026, I thought I will not also be invited till at least after 1 month when I'm going to retire. But let me assure you that I'll try not to lull my conscience too much. I wish that each state had a member in Rajya Sabha or in Lok Sabha, like Mr. John Brittas, who could espouse the cause of Justice Muralidharan, because there are number of judges from many states who face the same fate. For example, Justice Qureshi, and many others like that. We talk about only the higher judges who lost the opportunities. There are several unheard and unsung maladies of the judges who are there in the lower rungs of the judiciary. My concern is more for them, because these so-called judges occupying the higher positions are imitating the same procedure which rejected the opportunities for them. Let us think more about them. Federalism as we understand, let me also make one disclaimer before I come in speaking on the topic. Though I functioned as a judge of the constitutional courts for 4 long years, I did not have an opportunity to deal with any case in which federalism as such was involved. But both as a judge of a high court and as a judge of a district court, I dealt with hundreds and hundreds of cases in which the federalistic aspects within the meaning of federalism, in which I understand, came up before me. Federalism, as we understand, is only about division of powers between the center and the states. Apart from other aspects like bicameralism, supremacy of the constitution, and independence of the judiciary, so on and so forth. Federalism is not a new concept which is introduced for the first time by the Indian Constitution. It is as old as 4th century BC, when Aristotle in his works has described the 3 organs of the state. The ancient Roman Republic also followed the same concept. In the modern times, Montesquieu has made it more systematic and scientific in his work, The Spirit of Law, which has influenced the founding fathers of the United States for drafting the US Constitution, which was the first constitution in the world in 1789. So we had the vision of 4 constitutions before we drafted our constitution. Our constitution did not start on a tabula rasa. So we had the vision of these 4 constitutions. The US Constitution, as already said, 1789. And then the British Parliament Act, the British North American Constitution, 1867, and the 1900 Commonwealth of Australian Act. And then we have the Government of India Act both 1919 and 1935. So our constitution is modeled on the Commonwealth of Australian Act and the Government of India Act, for the reason that the US Constitution and the Australian Constitution did not have fully blown lists. They had only 2 lists with very enumerative subjects, whereas the other 2 constitutions had fully blown lists, 3 lists with a long length of lists. We know that federalism allows for accommodation of diversity and regional autonomy within a larger political unit, as said by just Mr. John Brittas, which is a very important aspect of federalism. Indian Constitution establishes a federalism with some unitary features, for which reason it is termed as a quasi-federalism. Dr. B.R. Ambedkar, at the time of drafting the Constitution, has remarked that the draft Constitution is meant both for the Union and also the federalism, meaning to say that we had a flexible federalism from day one. The reasons for leaving that flexibility for the federalism, perhaps going by the spirit with which the Constitution is drafted, must have been to make it more effective. Unfortunately, now that flexibility is being pushed to realize the vested interests of the governing bodies. We have, as already said, the federalism, the word of federalism is not used in our Constitution. But the Constitution lays down a structure for the government to function in a federalistic mode. And federalism has risen to the level that it had to be recognized as a basic structure of the Constitution. The Supreme Court in Satpal versus State of Punjab had upheld this principle, and the Indian federalism evolved from a unitary system under the British rule. And during the course of this evolution, it had to face several challenges like integration of the princely states, reorganization of the linguistic states, sharing of resources, the regional movements, demands for autonomy, interstate coordination, so on and so forth. We have various kinds of federalism, like holding together, coming together, asymmetrical. Ours being the holding together federalism, where the powers are shared between various constituent parts to accommodate the diversity in the whole entity. Powers are generally tilted towards the central authority. Though the Constitution speaks about the powers between the 3 organs of the legislature, executive, and the judiciary, the legislature occupies the first position and is placed in the first place for the reason that it makes laws and it holds the purse. The executive, which holds the sword, is supposed to implement the laws and execute the will of the state. And the judiciary is to interpret the laws and declare the law and act as a watchdog of the democracy and guardian of the Constitution. In Ram Javage Kapoor versus State of Punjab, the Supreme Court reiterated that the federalism is a part of the basic structure of the Constitution. That was a case filed by 6 persons who were carrying on the business in publishing, printing, and selling the school books. The Punjab government, in pursuance of its nationalization, issued notifications regarding this publishing and selling of the books, which consequently resulted in restriction of powers of the petitioners. So when the petitioners approached the Supreme Court said that no restriction can be placed on a right guaranteed by Article 19, Clause 1, Subclause G, by mere executive orders without proper legislation. And that legislation also is held to be conforming to the Article 19. We have Article 73 and 162 in our Constitution, which are analogous to Section 8 and 49 of the Government of India Act, which deal with executive powers of the Union and the states respectively. It was observed that our Constitution, though federal in its structure, is modelled on British parliamentary system, where the executive is deemed to have primary responsibility for the formulation of the government policy and its transmission into law, though the condition precedent is to retain confidence of the legislature branch of the state. So the executive function comprises both the determination of the policy and as well as carrying it into execution. Under Article 53, Clause 1, the executive power is vested with the President. But under Article 75, the Council of Ministers with Prime Minister as its head has to advise the President, thus making the President a formal constitutional head. The real power of execution lying with the Cabinet of Ministers with the Prime Minister as a head. Likewise, the same system at the level of the states with regard to the powers of the governor. So the Supreme Court commented that therefore we have the same system of parliamentary executive as in England, a hyphen which joins and a buckle which fastens the legislative part of the state to the executive. The cabinet enjoying the majority is in the vested control of both legislative and executive functions. So not going further deep into the facts of this particular case, it would suffice to say that though the Supreme Court has dismissed the petition in that case, it held that the executive government is bound to conform not only to the law of the land but also to the provisions of the Constitution. So even if the acts are deemed to be sanctioned by the legislature, they can be declared as void if they are found to be unconstitutional and arbitrary. So the core objectives of Indian federalism are unity in diversity, as already said, and also decentralization in administration. So through federalism, the state pursues the goal of common welfare in the midst of wide diversity of socio-cultural and economic spheres. There are several issues challenging federalism. One such is regionalism. We hear that the cry for cessation of the states is taking the center into jitters. Why so? It is said that the more the number of the states, the more the center will be caught hostage, and it has to yield to the pressures of the foreign countries. The example of West Bengal is stated. West Bengal threatened this Teesta Waters Treaty with Bangladesh because of its potential costs. If regional power grows, it is understood that they may affect effective foreign policy, as the federal government may bow to the will of the individual state. But I think that what is followed for the states which are in existence as of today can be followed for the states which are increased by division. So however, the powers of the union and the state are specifically enumerated in the list. This foreign affairs is within the purview of the central list. So regionalism can be controlled when a sense of unity is promoted among the states. If the policies of the center are made in a way to make every state self-sufficient in terms of resources, finance and political stability, the states would not be forced to claim any vested rights and create problems. It is only due to the lack of proper policies strengthening the state administration that the states make separatist cries. So any international policy is adopted for the welfare of the whole country at large. In making such policies, the interest of the state should be considered when there would not be any conflict between the center and the states. So fiscal federalism should be evolved in a manner suiting the interests of the states. So the constitution, we know, vests the center with greater powers of taxation. Imbalances between center and states should be corrected by the Finance Commission by determining the share of the states in the central tax revenue. Both the vertical and the horizontal imbalances should be addressed where revenue do not match the expenditure at different government levels and different regions of the country. So this asymmetrical sharing of the revenue and resource crunch results in uneven development across the country. If care is taken to strike uniformity and sufficiency, regionalism can be subdued, if not controlled. We are provided with indestructible union with a view to protecting unity and integrity of the country. This is thought as an arrangement which checks the growing demand for secession from Indian Union. In my opinion, creating checks for secession by constitutional impediments or otherwise will not improve the health of a nation. The needs for secession should be addressed so that there would not be any voice for secession. So in spite of all the challenges, federalism continued to be the most suitable form for a vast and pluralistic country like that of India. But restructuring Indian Federation, it can be made more effective. Impartial allocation to states, irrespective of the political considerations, and making the National Development Council more energetic and effective, and implementing the recommendations of the Administrative Reforms Committee that the Council should meet twice a year. NDC emerging as a verbal and effectual gadget of center state decisions in matters of development would address certain challenges. So uneven economic development and under-representation of some regions should be taken care of so that narrow-minded and anti-national forces can be contained. So independent judiciary, as is already dealt with by Mr. John Brittas, is one of the features of the federalism, apart from separation of powers and other. It's a central element of a democratic system. It's a unique feature which separates India from other countries. However, time and again, the independence of the judiciary has been facing challenges. Protecting judicial economy begins with the constitution governing the court. So judicial independence must also be continuously protected against unforeseen circumstances. For the prosperity and suitability of the country, we know that rule of law is very important. Maintenance of rule of law is possible only by an independent and impartial judiciary. Apart from these two challenges, we have another challenge which comes through religion. Religion has now become a big threat for the federalism. Justice Muralidhar is here. Namaste, sir. So I have heard about a very interesting thing on this religion. Recently, when I was listening to a debate of one parliament member, a female member, she was questioned on the incident where one of the female film directors, Leena Manimekalai, if I remember, she had made a film called Kali, in which she played the lead role. She released a poster of Kali smoking a cigarette with a LGBT flag in her hand. You all know that this aroused a lot of outrage from all sections of the society. When this particular parliament member was called upon to express her opinion on that, an interesting thing came to be known to me personally, that Kali is offered whiskey and other things as prasadam. That's their tradition. This was really a news to me. Not only Kali, but there are instances where few gods are offered with whiskey. Kerala also. So what would have happened if instead of a cigarette, that director had kept a glass of whiskey in her hand? I'm sure that the same outrage would have been there. So we don't believe basically that the prasadam offered by us will be consumed by the deity. We don't believe in our practices. We don't analyze about our practices. We have certain stereotypic understanding about how our God should be. She further said that God is an imagination of each individual. We were made to learn that God is not only for human beings, for the whole universe where we have several creatures. If ant has to imagine God, it will imagine God as a bigger ant with perhaps thousands of antlers or thousands of heads. Likewise, any other creature. So when we are under an imagination about a particular thing, curtailing the imagination of few people with your stereotypic belief, I think is unfair. If something goes wrong, if something is unlawful, if something is illegal, you have a right to curtail. But if with the same freedom with which you are allowed to practice a particular practice, if somebody else comes out with that freedom, it's unfair for anyone to raise voice against it. And it's more deplorable that those kind of voices are being backed by institutions, more particularly the governments. That is what really concerns us. I think understanding the aspect of secularism in a broader sense, in coordination with the other aspects of freedom, would better help the society to forge ahead. All the religions, each religion teaches only about tolerism. But now we are seeing the intolerism practiced by each of the religions. So when we are raising ourselves to practice tolerism and to think a while before you attack others, then I think the secularism will be better addressed. And let us talk about, I am concerned more about this. Justice Muralidhar is here. He is a director, elevated to the High Court maybe, but with all the zeal he has, because he is our teacher in Judicial Academy for several years, we could understand his zeal and understanding about the lower judiciary also. With all that, I am sure he'll accept with my opinion that federalism at the micro levels is very important. If I have any problem, I'll not go to the Chief Minister or the Prime Minister. I'll rush to the local police station. If I have to fight out my cause, I'll go to the local court, which is a lowest court in the ranks of the judiciary. So I need these institutions to be strengthened. I'm not really concerned about whether the Supreme Court is strong or High Court is strong. I want this Taluk Court to be strong. Who has to make this strong? We are talking about judges who do not get their deserves, not getting their elevations in time. I remember my colleagues also being very much worried about their elevations when our panel was sent to the Supreme Court and the government. I used to question them, have you given all the promotions in your unit on time? Just do that. You'll get your share of the democracy. Try to put everything on track from the lower rungs. If you mold the system from the base, this is the base. The lower courts are the base, the lower institutions are the base. There's a saying called Yada Raja Tada Praja, but I say Yada Praja Tada Raja. It's what you demonstrate that you need is what you get. It's not compromising on what you get that's going to satiate your needs. Everyone should be able to rise to that level where you can ask for strengthening the micro level institutions. The circles of influence now at the micro level institutions is the concern. We know how the micro level institutions function. They feel the supremacy. Each one of them feels a supremacy. So this is injected by the people who are in power. We were always, when we went to Judicial Academy, we were taught that you are not going to assume any power by becoming a judge. You are only taking up a responsibility on yourselves. So try to be conscious of that. When alone you will be able to discharge your functions as expected by the society. So friends, my appeal to all of you is, if you at your individual levels strive to put the things which are at your disposal on right track, it will take care of everything. Let not the salt lose its flavor to raise a question as to who is going to salt the salt. Thank you.
Thank you, madam. You said, well said, that majoritarianism is antithesis of federalism, and federalism must strike roots from the lowest, and where everyone, every part of the country must feel that it is part of the same country. Thank you.
Before going for a vote of thanks, I request Parthasarathi to present some books which are small, not his gift, but and I request all the audience to keep in your chairs, because immediately after completion of this session, the next session will be commenced, and Sri Justice Muralidharan is among us, so don't leave your seats. I request Madhav Reddy to offer vote of thanks.
Respected chair of this second session, we are gratefully thankful to our keynote speaker today, sir, John Brittas, member of Parliament, Rajya Sabha, who all the way came from the Delhi to address us. We are very grateful to you, sir. Thank you very much. And also we are thankful to Madam Justice Rajni Madam Garu, who all the way came from Vijayawada to address us and spoke as very. Thank you, sir. And also I thank for our Durga Prasad Garu, who chaired this session. Thank you, one and all. Please wait for third session. Thank you.
Hello, I request all the advocates and other members not to leave the hall. We are commencing the next session, please. I request Venu.
Good afternoon, friends. We are going to start third session, and our distinguished guests also present here. Please be seated in your seats. సో ఈరోజు ఇక్కడ జరుగుతున్న నేషనల్ సెమినార్లో మూడో సెషన్ స్టార్ట్ కాబోతుంది. ఈ సెషన్కి ముఖ్య అతిథిగా విచ్చేసిన రిటైర్డ్ జడ్జ్ ఆనరబుల్ జస్టిస్ శ్రీ ఎస్ మురళీధర్ గారు, ఫార్మర్ చీఫ్ జస్టిస్ ఒడిశా హైకోర్ట్. ఐ రిక్వెస్ట్ Sri Justice Muralidhar garu to come on to dais to occupy his chair. For this third session is chaired by Srimati C.H. Shailaja, convener, AILU Women Subcommittee, Telangana State. I request Sri Shailaja garu to, okay. I request Madhava Reddy garu to present bouquet to our chief guest of this session, Sri S. Muralidhar garu. I request Narendra Reddy to present bouquet to chairperson. I request to the chairperson to conduct the session.
Sorry, madam, please let me announce some a factual issue which has happened, which is more befitting before we call upon Sri Justice Muralidharan to address all of us. I request the organizers to display one video. Thereafter I will comment on it.
It's great.
I think all of you might have witnessed this video, and this is not that a simple YouTube video. This is a video which is reflecting the respect commanded by our chief guest, Sri Muralidharan Garu. When he was retired as a Chief Justice of Orissa High Court, this was the grand farewell given by the advocates, staff, clients, everyone. Yes, almost in the entire complex, he was taken in throughout the complex, and he was given such a farewell, which so far no judicial officer had taken at any point of time from the time of our establishing of High Courts or Supreme Court. So, we have such a towering personality among us, and who is a victim in the hands of union government. As earlier speakers said, today we might not have even got an appointment unless we introduce ourselves as organizations or likewise, if he would be the person who is elevated to the Supreme Court. But unfortunately, the persons who are juniors to him were elevated as Supreme Court judges by bypassing his seniority. So I say that he is a victim in the hands of union government, and he is not feeling any regret for this. Now he entered into the field where he wants to enrich the people with regard to the rights which are enriched to the common man, that is to say the Constitution of India. So he is now the torchbearer. He is now the torchbearer of the society. I request Srimati Shailaja Garu to continue the proceedings.
థ్యాంక్ యూ సార్. నా భాష తెలుగు కాబట్టి తెలుగులో మాట్లాడే ప్రయత్నం చేస్తారు 2 నిమిషాలు. మార్నింగ్ నుంచి సెషన్కి వివిధ ప్రాంతాల నుంచి వచ్చి మనందరం కూడా కాన్స్టిట్యూషన్ పైన ఉన్నట్టు నమ్మకం, ఎందుకంటే కొందరికి పవిత్ర గ్రంథం భగవద్గీత, మరికొందరికి బైబిలు, మరికొందరికి ఖురాన్, కానీ నాలాంటి వాళ్ళందరికీ కాన్స్టిట్యూషనే పవిత్ర గ్రంథం. అలాంటి గ్రంథానికి తూట్లు పడి అలాంటి గ్రంథాన్ని అమలుపరిచే భాగంలో మనం ఎన్నో ఇబ్బందులు ఎదుర్కొంటున్న సమయంలో ఇప్పుడున్న పరిస్థితుల్లో కాన్స్టిట్యూషన్ యొక్క వ్యాలిడిటీ, అడ్వకేట్స్ పైన మనకున్న బాధ్యతని మనం గుర్తెరగాలనే ఉద్దేశంతో ఆల్ ఇండియా లాయర్స్ యూనియన్ తెలంగాణ రాష్ట్ర కమిటీ ఈ కార్యక్రమాన్ని ఏర్పాటు చేసింది. 2 సెషన్స్ అయిపోయాయి. థర్డ్ సెషన్, లాస్ట్ సెషన్ బట్ నాట్ ది లీస్ట్ సెషన్. ఇప్పుడే మీరు చూసారు మంచి వీడియోని విత్ రిగార్డ్ టు ది మురళీధరన్ సార్. So with these words, I request our chief guest for the third session, Sri Muralidhar Garu, who is the former Chief Justice of Odisha, and address the matter to the public.
A very warm good afternoon to everyone present here. I consider it my honor and privilege to be invited by the All India Lawyers Union Telangana chapter to address this vibrant gathering on a very important topic of secularism as seen through the eyes of the judiciary. At the outset, I wish to thank the organizers, and in particular Kolli Satyanarayana Garu and Madam Shailaja, who is presiding over this session, Shri Kunduri Viraya, Shri Pathasarthi, General Secretary, Shri Madhav Reddy, who accompanied me from the airport, and all office bearers of the AILU, and all the distinguished members of the audience present here. While preparing for this topic, I had to go through a number of judgments of the Supreme Court, but I first wanted to draw out a context in which we are addressing this important topic today. In fact, all of today's topics, Justice Nageshwar Rao spoke on the basic structure, Shri Bitras on federalism, and this topic of secularism. I think all of these we identify as basic facets of our constitution, which embodies democracy through the rule of law. When we made our own constitution, the whole process of making the constitution gives a very useful insight into the complex nature of that exercise itself. I'm not so much going into the composition of the Constituent Assembly, but the level of the debate in the Constituent Assembly. Today's atmosphere, many of us feel, has raised the pitch. In a democracy, that's not an unwelcome thing. Debate is always welcome in a democracy. Discussion, dissent, differences of opinion, all are not unusual in a democracy. How civil we keep this debate, how we are able to provide space for this debate is what the real issue is all about. In fact, a platform like this is so important. I must really commend AILU for organizing seminars like this, particularly at a time when there are questions being raised about the basic structure of the Constitution itself. There are voices being heard about whether we need a different Constitution, whether there are colonial elements of the Constitution that need to be removed. So this is as good a time as any to discuss many of these important facets. This is a time when we find that there is greater intolerance to differences of opinion. There are very, very violent reactions to differences. There is an attempt at forcing a certain point of view at the tip of a knife. So there is a general fear, pervading fear, that if one speaks out, one may have to pay for having to speak out. There is what is called self-censorship. I don't know how many of you heard of this author, John Pilger, who was himself a renowned journalist, a veteran journalist. And he's written several books. One autobiographical sketch is called Hidden Agendas. Many of you must have heard in the recent past that Rupert Murdoch, the media mogul who owns the Fox Corporation, which has several channels, and not only in the US, but all over the world, including UK, and was also in a tie-up with Star News here in its initial avatar. Rupert Murdoch is supposed to have stepped down as chairman of the Fox Corporation. But it is said that Rupert Murdoch controlled the way media operated after he took over. John Pilger writes in Hidden Agendas that as a journalist working in a news organization, he could sense that when a journalist was told that his or her newspaper or electronic media channel has been taken over by Rupert Murdoch, journalists would themselves stop writing certain stories. They would themselves sense what is correct to be written, what is not correct to be written, what will pass and what will not pass. There was no need to dictate the change in policy. And that sure spells a death knell for democracy. If you have to constantly censor yourself, not just in public conversations, but even in private conversations, then it is a cause for worry. That is the time when we need to revisit our own notions, our own held beliefs, and whether this is the kind of society that we want to live in, whether this is the kind of society that makers of the Constitution envisaged on 26 November 1949 when they adopted the Constitution. It is in this atmosphere of growing intolerance, of fear of speaking freely, that we need to address this topic of secularism, because much of the turmoil that we are seeing is associated with issues of secularism, of closely held religious beliefs, of what are the rights of minorities, not necessarily religious minorities. And much of these issues were anticipated by the constitution makers. So I wanted to start today's discussion with all of you with a short clip from Shyam Benegal's TV series called Samvidhan, which tells us what the constitution makers were concerned about when they all sat down to making our constitution. So with your kind permission, I'll request the playing of that clip. Should I show you which the clip is? Samvidhan.
अगर हम सब ये चाहते हैं कि अंग्रेजी की जगह हमारे मुल्क की जबान तमाम मुल्क की कौमी और फेडरल जबान हो जाए, तो इस वक्त हमारे सामने इसके सिवा और कोई चारा नहीं है कि एक मुद्दत तक हम सब्र और इंतजार करें। जहां तक जबान का ताल्लुक है, तो आम तौर पर यह बात मान ली गई है कि कौमी जबान वो जबान हो सकती है जो उत्तरी हिंद की जबान हो, लेकिन इस वक्त उत्तरी हिंद की जबान के लिए 3 नाम पैदा हो गए हैं: उर्दू, हिंदी और हिंदुस्तानी।
चंद मिनटों में यह असेंबली पूरी तौर से आजाद खुद मुख्तार असेंबली हो जाएगी और नुमाइंदगी करेगी एक आजाद खुद मुख्तार मुल्क की। हमने एक मंजिल पूरी की है और आज उसकी खुशियां मनाई जा रही हैं, लेकिन ये भी हम जानते हैं कि हिंदुस्तान भर में खुशी नहीं है।
We are going to enter into a life of contradictions. In politics, we will have equality. And in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one vote, one value. In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value.
कमिटी में इस विषय को लेकर 2 तरह के मत थे। एक ये राय थी कि नागरिकों को ज्यादा से ज्यादा अधिकार देने चाहिए, जिनकी बिना पे वे सीधी तरह अदालत में जाकर अपने हक सिद्ध करवा सके। और दूसरी ओर ये राय थी कि बहुत ही कम मगर अहम मूल अधिकारों तक फंडामेंटल राइट्स को सीमित रखना ही उचित होगा।
Mr. President, the flame of God is invoked by every nation upon earth, and God is an impartial entity, and he should be allowed to remain so. With these words, I appeal to Mr. Kamath not to put us into any embarrassment of voting upon God.
It is said that the state should, within a period of 10 years, introduce free compulsory education. Let us assume that the state does not do so. Then, can any court of law enforce it? Against whom? In case a decree is granted by court of law, who will carry it out? If the government does not carry it out, can the High Court or Supreme Court enforce it?
The great problem in providing for and guaranteeing fundamental rights in any constitution is where to draw the line between personal liberty and social control. True liberty can flourish only in a well-ordered state, and when the foundations of the state are not imperiled. The problem of minorities has been solved by common agreement in a manner satisfactory to the various parties concerned, and the draft constitution merely seeks to give effect to the agreement reached.
जब आज वर्षों के संघर्ष और जद्दोजहद के बाद हम अपने देश के शासन की बागडोर अपने हाथों में लेने जा रहे हैं, हमें उस परम पिता परमात्मा को याद करना चाहिए जो मनुष्यों और देशों के भाग्य को बनाता है.
So that was the Constituent Assembly, which saw stalwarts, of course, all enacted by some of the best actors that we have. So among the first speakers, if those young enough not to recognize some of them, the first speaker who was shown there was Maulana Azad, a great educationist, who was speaking about the tussle over what should be the language. So if you remember, we don't have a national language, we have an official language. And there is still that tussle going on. So this is 1949, today we are in 2023. And you will realize that how some of these issues still are matters for debate. The second speaker was, of course, Pandit Nehru. The third speaker was Baba Saheb Ambedkar. The fourth speaker was Sardar Patel, who pointed out about enforceability of rights. Again, an issue that's still alive. The fifth speaker, many of you may not be aware, was Purnima Banerjee. And for today's topic, what she says there is very relevant when she asks the assembly not to vote upon God. This is because Mr. M.V. Kamath, who spoke immediately after her, wanted to actually table an amendment which said, in the name of God, we the people. So he wanted to start the whole reading of the Constitution in the preamble with the words in the name of God, and faced resistance from members of the Constituent Assembly only because they felt that is not something that they should be voting upon. But it also underscored the anxiety of the members of the Constituent Assembly that they should affirm secularism as a principle in the Constitution. The next speaker you heard was Alladi Krishnaswamy Iyer, a senior lawyer from Madras who was one of the guiding forces in the subcommittee on fundamental rights and minority rights, and he believes that they struck the compromise and adequately protected minority rights. In fact, as part of the part 3 of the Indian Constitution, you have a whole series of rights beginning with Article 25 up to Article 30, which addresses the concerns of the minorities, and not just religious minorities, but also linguistic minorities. The last speaker was Babu Rajendra Prasad, presiding over the Constituent Assembly, who then later on became the first president of India. And ironically, he invokes the name of God to thank for the success of the Constituent Assembly. So you could already see the tensions of the Constituent Assembly as to what is the position they need to take as far as the concept of God is concerned, whether they should foreground God as a concept in making the Constitution, as Pakistan has done when it foregrounds the salutations to Allah in the Constitution itself. Later, this was looked upon very carefully by the Indian Supreme Court, and this was seen as underscoring the fact that India is not a theocratic state. India could easily have proclaimed itself to be a Hindu nation, but there was a conscious choice made by the constitution makers, acknowledging the diversity and plurality of India, that it will not go down that route of becoming a theocratic state. Much more needs to be spoken about this, and I'll quote the words of the Supreme Court itself on this. But what is therefore important to note is that this was very much in the minds of the constitution makers when they debated these issues at the time of making of the constitution. One of the members of the Constituent Assembly was K.T. Shah, who belonged to the Indian Socialist Party. In fact, again, for those who may not be aware, it is not that the Constituent Assembly members all came from just the Congress party of that time. They came from diverse fields. And they supposedly represented several interests whose concerns needed to be addressed. So K.T. Shah tried to table an amendment to include the word secular in Article 1 of the Constitution itself. And he wanted to include these words, secular, socialist, federal. Now that amendment in 1949 was opposed. Why Shah wanted the amendment, in his own words, was this, and I quote him: "The secularity of the state must be stressed in view not only of the unhappy experiences we have had last year," and he's referring to the partition, "and in the years before, and the excess to which, in the name of religion, communalism or sectarianism can go, but I intend also to emphasize by this description the character and nature of the state which we are constituting today, which would ensure to all its peoples, all its citizens, and that in all matters relating to the governance of the country and dealings between man and man, dealings between citizen and government, the consideration that will actuate will be the objective realities of the situation, the material factors that condition our being, are living, and are acting. For that purpose and in that connection, no extraneous considerations of authority will be allowed to interfere, so that the relations between man and man and relation of citizen to state, relations of states inter se, may not be influenced by those other considerations which will result in injustice or inequality as between several citizens that constitute the people of India." So as I was saying, he wanted insertion of secular and socialist in Article 1, Sub-Article 1. And Babasaheb Ambedkar, in rejecting that request, somehow did not refer to the word secular at all, but only the word socialist. And this is what he said: "If you state in the Constitution that the social organization of the state shall take a particular form, you are, in my judgment, taking away the liberty of the people to decide what should be the social organization in which they wish to live. It is perfectly possible today for a majority of people to hold that the socialist organization of society is better than the capitalist organization of society. But it would be perfectly possible for thinking people to devise some other form of social organization which might be better than the socialist organization of today or tomorrow. I do not see, therefore, why the Constitution should tie down people to live in a particular form and not leave it to the people themselves to decide for themselves." So this really addressed the demand for insertion of the word socialist, and not so much the demand for insertion of the word secular. As a result, in fact, there were two other amendments moved by others for including secularism in the Constitution in 1949 itself, which the Constituent Assembly did not agree. And as a result, you find today in the Constitution reference to the word secular, apart from in the preamble, which came about only in 1976 through the 42nd Amendment. You find a reference only in Article 25, Sub-Article 2, Clause A. So 25 talks of freedom of conscience and free profession, practice and propagation of religion. And 25.2 reads, and I quote, "Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice." So this is the only place in the entire Constitution, apart from the preamble, where the word secular occurs. And even in the preamble, it came at a time of the emergency and for purely political reasons, which readers of history will be aware of, students of political science will be aware of, but which I need not dwell upon too much at this stage. The word secularism otherwise permeates the whole of Chapter 3. When we take Article 14, Article 15, and of course the Articles 25 to 30, there can be no mistaking that there was understanding of what constituted a purely religious activity and what could constitute as a secular activity. The equality of law and equal protection of the law that has been used to justify, for instance, the Shaira Banu judgment, where triple talaq was struck down by the Supreme Court on the anvil of Article 14, because Article 14 is seen to be the secular provision in the Constitution. Likewise, taking over of Hindu religious institutions through enactments, where you've had a whole series of enactments of taking over the running of temples, the Vaishnava Devi temple, for instance, in Jammu, that is governed by a statute. The Waqf Act, which takes over the running of Muslim institutions, because these activities of administration, dealing with finances, distribution of work, all of this which an institution might perform is seen as in the realm of being a secular activity and protected by Article 25(2)(a). It gives the power to the state to make a law to restrict any economic, financial, political or other secular activity that may be associated with religious practice. But as I will come to it later, there is a backlash against this in the recent past, where questions have been raised as to why state governments should be given the power to run religious institutions if we are a truly secular country. And that brings us the question about what is the Indian nature of secularism. Secularism has many forms. Under the American Constitution, it connotes strict separation of the state from religion. Neither state can interfere in religious affairs, nor will religion be allowed to interfere in state affairs. A wall of separation exists between religion and state as far as the United States is concerned. And this is despite the fact that many US presidents or presidential candidates have to demonstrate that they're God-fearing, that they go to the church, that they have a family. All these become very important parameters for the voters to decide. On a lighter tone, many male US presidential candidates will not be seen wearing spectacles. So that is one of those facts that they have there. But the point I'm making is this. The American version of secularism is something that we did not follow and cannot follow for reasons that I will speak about. The French notion of secularism is that the government can interfere in religious affairs, but not vice versa. Therefore, the display of religious symbols. France is very particular that hijab should not be worn. Although hijab is simply a headgear and should not offend anyone at all, but in France, they make a fetish that we will not permit wearing of hijab in schools. That was the French notion of secularism. The Indian notion of secularism, as understood by the judgments of the Supreme Court, is one of tolerance of all religions. But there has been a more nuanced understanding of this. I'll come to that in a minute. So the earliest attempted definition of secularism was in a judgment which the Supreme Court delivered in the context of challenge to the power of the Muslim minority denomination to excommunicate its members. So one of the first articulations of this was by Justice Rajagopal Iyengar, and this is what he had said while interpreting Articles 25 and 26, and I quote this. Articles 25 and 26 embody the principles of religious toleration that has been characteristic feature of the Indian civilization from the start of history. The instances and periods when this feature was absent being merely temporary aberrations. Besides, they serve to emphasize the secular nature of Indian democracy, which the founding fathers considered to be the very basis of the Constitution. If you see readings of Indian history, you will find that from the time of Emperor Ashoka, where he used the hyphenated term Brahmanas and Shamanas, and he said we should, and Ashoka, as you know, was one of the major propagationists of Buddhism. But Ashokan edicts tell us this principle of tolerance, of live and let live, and this has been quoted in several judgments of the Supreme Court, only to emphasize that the Indian version of secularism is different from the European or American notion of secularism. Then we have, of course, the Keshavananda Bharati case, where secularism is identified as one of the basic features of the Constitution, which cannot be amended away by Parliament. So the Parliament's power of amendment under Article 368 is curtailed by this notion of basic structure, and the amendment power is therefore hedged in, and that is what is now being questioned. So you will know why that question is now arising, because the Parliament wants, in a sense, to regain its power to amend the Constitution, even to take away its basic features, of which even secularism is one. In St. Xavier's, Ahmedabad St. Xavier's College, Society versus State of Gujarat, this was a judgment of 9 judges, which was delivered in the year 1973, 1974. 2 of the judges, Justices Matthew and Justice Chandrachud Senior, this is what they had said: the Constitution has not erected a rigid wall of separation between the church and the state. It is only in a qualified sense that India can be said to be a secular state. There are provisions in the Constitution which make one hesitate to characterize our state as secular. Secularism in the context of our Constitution means only an attitude of live and let live, developing into an attitude of live and help live. Then we have the case of Ziauddin Burhanuddin Bukhari, where the Supreme Court went on to define secularism in the realm of philosophy and in utilitarian terms. That was an election dispute where seeking votes in the name of religion was decried, and the election was invalidated on that ground. The candidate said, I am the true Muslim and you should give votes to me and not to my opposing candidate who is not a true Muslim. And that was seen as inciting religious hate. Then we have the expanded notion of secularism in the Indira Sani case. In the Indira Sani case, which was in the wake of the Mandal amendments, where the central government of the day, based on the Mandal report, reserved 27% of jobs, government jobs, for other backward classes. The challenge was raised in the Supreme Court. Mr. Palkiwala was arguing for the petitioner, and in upholding those reservations, but saying that it will not be beyond a certain period of time, the Supreme Court also carved out what is called the creamy layer test to test the validity of reservations. Justice Kuldeep Singh, in that judgment, stated that secularism envisages a cohesive, unified, and casteless society. And Kuldeep Singh's opinion states, and I quote, caste poses a serious threat to secularism and as a consequence to the integrity of the country. So the Supreme Court is now enlarging the concept of secularism and recognizing that the caste distinctions that we've made, which Dr. Ambedkar recognized very early on, can be a serious threat to the integrity of the country, and therefore secularism had to be seen also in the terms of caste. Then we have the Bombay judgment. S.R. Bombay, as you know, that BJP ruled governments in the wake of the Babri Masjid demolition were dismissed by the central government of the day, and the Supreme Court upheld those dismissals. Of course, they built in a lot of precautions, saying that the proclamation had to be placed before Parliament and voted upon and cannot continue indefinitely, the President's rule proclamation. But in that process, there was a talk of secularism. This time, again, the Supreme Court reaffirmed that secularism is part of the basic structure of the Constitution. And Justice K. Ramaswamy, who came from the Andhra Pradesh High Court to the Supreme Court, the undivided Andhra Pradesh High Court to the Supreme Court, explained that programs or principles evolved by political parties based on religion amount to recognizing religion as part of the political governance, which the Constitution expressly prohibited. Basically, what Justice Ramaswamy is trying to say is, in public affairs, keep religion out. And now you can see how that is all being seriously challenged. in our public discourse, we find chief ministers donating monies to temples and making sure that it is public. We have political personalities associating themselves with yajnas, yagas, all religious functions. These are being official functions of governments which endorse a particular religion. So we have traveled a long way because of the political climate of the day, which raises a serious challenge to this understanding of secularism. Justice Ramaswamy says it is the duty of the court to bring every errant political party in line if it goes against the secular ideals like casteism and religious antagonisms. So in that process, both Justice Jeevan Reddy and Justice Suresh Agarwal, who were part of the bench in Bombay, they agreed with Justice Ramaswamy and went on to underline that the concept of secularism in the Indian Constitution is in agreement with the US Constitution's First Amendment. So two of the judges seem to endorse this wall of separation between the state and religion, which is not quite true. And as we will see that the balance is restored, but in an extreme way in the subsequent judgments that came in Ismail Faruqi versus Union of India. Ismail Faruqi, you will understand, is the judgment delivered by the Supreme Court by a majority of 3:2, upholding the validity of the acquisition of certain properties on Ayodhya Act. The central government took over the property in which the Babri Masjid was located and where the temporary structure came up in the wake of the demolition. And the question was about the validity of that statute itself. And there, the Supreme Court went into the question of what is an essential religious practice. They said praying in a particular place is not a fundamental right of the minority community, and they can't insist that that is a fundamental right, and therefore upheld the statute itself. But that shifted, in some sense, the understanding of secularism, because in the majority judgment of Justice J.S. Verma, for himself, Justice Venkatachalaya, Chief Justice Venkatachalaya and Justice G.N. Ray, Justice Verma went on to quote from Yajurveda, Atharva Veda, Rig Veda to justify the concept of secularism. So you will find an odd thing happening here. You quote a religious scripture to justify secularism. And according to him, these scriptures talked about Sarva Dharma Sambhava, that is tolerance of all religions. So it was, in a sense, justifying secularism by religious scriptures. So the Bombay understanding of secularism was not adhered to, and the dissent, of course, while acknowledging that Hindus are the majority community, still believed that the Indian Constitution has a different flavor of secularism which needs to be protected. In fact, in that context, I wanted to just refer to what Baba Sahib Ambedkar told the Constituent Assembly at the time of the final draft. He said, no minority in India has taken the stand that we don't want to be ruled by you. They have loyally accepted the rule of the majority, which is basically a communal majority and not a political majority. It is for the majority to realize its duty not to discriminate against the minorities. Whether the minorities will continue or will vanish must depend on this habit of the majority. The moment the majority loses the habit of discriminating against the minorities can have no ground to exist. Again, Dr. Ambedkar is prophetic. He apprehends very rightly, and like he apprehended in that clip that you saw, that the absence of two things, which is equality and fraternity. He reminded us in 1949, and here he's talking of discrimination against the minorities and what the majority is expected to do in a constitution and which encompasses rule of law. We then have the Hindutva judgments, as they are called, a triumvirate of judgments, Yashwant Prabhu versus Kunte, which is challenging of elections held in Maharashtra, where the Shiv Sena many leaders of Shiv Sena addressed public rallies, and one of those rallies, they actually said, we want to establish a Hindu rule in Maharashtra. So Justice Verma in commenting on that, he said the leaders should be more circumspect and careful in the kind of language they use, and stated that the statement that the first Hindu state will be established in Maharashtra is by itself not an appeal for votes on religious grounds, but the expression at best of such hope. And Justice Verma then went on to equate Hinduism, Hindutva, and Indianization. And this is what he said, I'll quote, "The words Hinduism or Hindutva are not necessary to be understood and construed narrowly, confined only to the strict Hindu religious practices, unrelated to culture and ethos of the people of India, depicting the way of the life of the Indian people." So again, in a series of cases, they tried to explain that there was no inherent contradiction between the nature of secularism that was explained in Bommai to these judgments, the Hindutva judgments, where they're basically saying that secularism is even part of the religious scriptures like Rig Veda, Yajur Veda and Atharva Veda. What this has also brought up is the role of the court. Unlike other jurisdictions, the Indian courts seem to take upon themselves the task of determining what can be strictly a religious activity and what is a secular activity. Very often you've had religious groups whose activities are sought to be controlled by the state, whose secular activities are sought to be controlled by the state, going to the court and saying, our essential religious practice is being affected. For instance, you'll have the Anand Margis going to the court and saying that Tandava dance is an essential religious practice for us, and we should be allowed to perform the Tandava dance in public. The Supreme Court went as far as saying that, okay, even if we, for a minute, accept that the Tandava dance is an essential religious practice for the Anand Margis, performing it in the public might give rise to law and order because they're supposed to carry spears and other weapons when they perform the dance, and therefore we will not allow it to be performed in public. You had the Ramakrishna Math going with the Supreme Court and saying that we are a different religious denomination and not strictly a Hindu denomination, and therefore we should not be controlled by the government. That is an argument which was accepted by the Calcutta High Court but rejected by the Supreme Court in a judgment. Then we've had the Shirur Math case of 1954, where the first attempt was made as identifying what is a strictly religious practice, essential religious practice, and what is not. Then we have the Dargah Committee case, where again the court said, speaking through Justice Gajendra Gadkar, that the court will have to be very careful in not accepting any and every practice as an essential religious practice. If I may just quote that, and that is relevant for what I'm going to now say. I'll come to that in a minute. What has happened is this distinction that the court makes between essential religious practice and a secular practice has become the bone of contention in the Sabarimala case. The question in the Sabarimala case was trying to amend through regulations the entry of women between the ages of 10 and 55 in the Ayyappa temple. That was challenged, and one of the grounds of challenge was, of course, a technical challenge, saying that the Act itself does not have such a restriction. How can you introduce it through regulations? So the majority, which is 4:1, agree that you can't do it through regulations and strike down that regulation. But the majority goes on to find whether it's essential tenet of that particular practice that women are kept out. And Justice Chandrachud, the present Chief Justice, evolves what is called an anti-exclusion test. He says the preamble itself foregrounds individual dignity, and therefore the dignity of women is seriously affected if they are going to be treated as untouchables, and that is abhorrent to human dignity and to Article 17 of the Constitution. And therefore this very regulation must fail on that ground as well. Now what it has happened as an aftermath of Sabarimala is very interesting. although 5 judges by a majority of 4:1 permitted entry of women between the ages of 10 and 55 in the Sabrimala temple, within a few months, a different composition of the bench admitted, with one of the changes being the presiding judge, admitted what is called a review petition, with again a dissent of 2 of the members of the Constitution bench, Justice Rohinton Nariman and Justice Chandrachud. So the split majority of 3:2 admitted the review petition. A further petition was filed questioning whether this could be done in the same case by a subsequent 5-judge bench, and the 9-judge bench upheld this admitting of the review petition. The review petition has been admitted on this very ground of essential religious practice, whether the court can take on this exercise or should leave it to the religion itself to determine, the religious denomination itself to determine what is its essential religious practice. So this is a question that is still at large. It hopefully will get settled sometime soon. Right now, therefore, the Sabrimala judgment also, although it is a 4:1 judgment, is not yet the law of the land. It has been put in hibernation. I could go on and on secularism and the Supreme Court. Basically, what we need to understand is the judge's understanding of secularism is through texts themselves, commentaries themselves, whether it's Islamic law in the terms of triple talaq, or whether it's the Waqf Act which is being questioned, or in the Chidambaram Dikshidhar case, very recently Subramanian Swamy was the state of Tamil Nadu, where they said that the right of the Dikshidhars to perform, to take over the administration of the Chidambaram temple can't be taken away by the government. In fact, it was a victory for the Chidambaram Dikshidhars. Recently, you've had, just last week, the Supreme Court staying a measure by the Tamil Nadu government recognizing non-Brahmins as priests and women as priests. So this seems to be a lot of tension between what a government wishes to do, which is a popular government elected by the people, and what the Supreme Court views as an essential religious practice which cannot be trammeled upon by the state government. That tension continues to exist. But the point that I'm trying to make, like there's a judgment which goes by the name of Bal Patil versus Union of India, where Jains went to the court and said Jains should be treated as a religious minority. Now, although Jains are a religious minority in a sense, but you will notice under the Hindu code, whether it's the Hindu Marriage Act, the Hindu Succession Act, Jains and Sikhs are bracketed with Hindus. And a conscious decision was made to treat them as Hindus. Now, Jains want to assert that, no, we are a separate religious denomination and we must be recognized as a minority. But that was shot down in Bal Patil versus Union of India. And Justice D.M. Dharmadhikari, who is the judge who gave that judgment, says this: the country has already been reorganized in the year 1956 under the States Reorganization Act on the basis of language. Differential treatments to linguistic minorities based on language within the state is understandable. But if the same concept for minorities on the basis of religion is encouraged, the whole country, which is already under class and social conflicts due to various divisive forces, will further face division on the basis of religious diversities. Such claims to minority status based on religion would increase in the fond hope of various sections of people getting special protections, privileges, and treatment as part of the constitutional guarantee. Encouragement to such vociferous tendencies would be a serious jolt to the secular structure of constitutional democracy. We should guard against making our country akin to a theocratic state based on multinationalism. This is very important for us to understand in the context of secularism, and how we should not be encouraging further assertions of recognition as religious minorities and for getting privileges on that basis. This has been reiterated in the Coelho judgment, and before that in the Nagaraj judgment. And this concept of secularism, which was spelled out in 25 to 30, has been used by the Supreme Court to protect the right of the Jain minorities in Gujarat to have the sale of meat banned during their religious festivals. So this is the judgment in Hinsa Virodak Sangh versus Mirzapur Moti Quresh Jamaat. You will understand when I say this, and this is on a lighter note, we had the Hanif Qureshi judgment, which permitted slaughter of milch cows, buffaloes, after an age of 14, when they had stopped producing milk, and this was a judgment of 1956. This Hanif Qureshi judgment, which was by 5 judges, stood reversed in state of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat, which is a 2005 judgment. And they used Article 48 to say there can be a complete ban on slaughter of cattle and not necessarily milk producing cows. Even bullocks, there could be a complete ban on slaughter of all such animals. And on a lighter note, the composition of that bench had 6 vegetarians and 1 non-vegetarian. And it was a non-vegetarian judge who wrote the dissent. So even composition of benches to deal with issues like this become important. There are several issues that I thought I should flag when we are discussing secularism. One is the changing nature of the polity, where I pointed out earlier, assertion of majoritarianism and of religious majority, and wanting the state to be shaped in the vision of that religious majority. This is a development that has taken place in the last 10 years, which we must acknowledge, which is what is giving rise to all these debates that we're having in the public domain. I think one important trigger for this was the Ayodhya judgment itself. For the first time, we had the Supreme Court issuing a mandamus to the central government regarding construction of a temple. So that was not even the prayer made in the suits, but this was a relief granted in the Supreme Court in the judgment, which is a unanimous judgment, that the government should take steps to build a temple at the disputed site. So what this does to the concept of secularism, when it's a judgment of the Supreme Court itself, is the question. Second is, which I mentioned earlier, this notion, that is the monarchic notion of the ruler of the country being the defender of the faith. So that whole notion that, in every important function concerning the state, there must be a religious basis for it. There must be a religious legitimation of it, like you saw in the inauguration of the parliament. So what that does, again, to this notion of secularism is something that we need to reflect on. Then we have the codifications of the Hindu code, which met with serious resistance. I think scholars of legal history will go back and see the pitched battles that were fought in the parliament and led to the resignation of Baba Saheb Ambedkar as a law minister from the very first cabinet. When the Hindu code came about, when the Hindu Marriage Act, Hindu Succession Act, and even now the amendments to the Hindu Succession Act, which recognizes the rights of women to co-parcenary property, to recognize as a co-partner and to co-parcenary property, that tells us the tensions, existing tensions between our understanding of the Hindu religion and what it permits and what it does not. But the expanded notion of secularism that the Supreme Court has brought about, which includes gender diversity. Sabarimala is an important recognition that in the name of a religious practice, you cannot discriminate against women. That needs to be debated about. It will be debated when the 9-judge bench, when the review bench revisits the whole notion. And also expanding it to make it plural and inclusive so that it deals with the issue of caste discrimination. Much of caste discrimination is coming through what we understand to be a religious practice. And at this stage, I want you to reflect on something that is very disturbing in our society, that caste discrimination is not confined to the Hindus. Those in the audience who may not be aware of it, I just want to remind you that this is something that we seem to have carried across religions in India. Whether it's the Muslims, whether it's the Sikhs, whether it's the other religious minorities, caste seems to be a supervening factor which determines all our actions, particularly choices of marriage. And within the Dalits, there is a caste hierarchy. So I want us to just see the small clip which comes from a documentary called India Untouched. This is there on YouTube. I want each of you to watch this documentary. It is called India Untouched. It's made more than 12 to 15 years ago. And it's done through interviews with actual people. It's not a fiction, it's actually a documentary, a non-fiction. So I just want to play that small clip.
नहीं होगा ये बहिस्ती ज़बर में लिखा हुआ है अब हम सिख हैं तो सिखई में होगा, पैठान में नहीं हो सकता है, जोला में नहीं हो सकता है।
क्यों?
अपना ही में न होगा।
ये मुसलमानों में जो है
सबसे बड़ा जाति है।
आपसे में रिश्ता करना है, शादी करना है तो दिल का दिल के साथ होएगा, जट से का जट के साथ।
क्यों?
I prefer so. I had a belief in one caste. I like to invite a man to my life who is from the same caste.
എനിക്കൊരു സവർണ്ണ ക്രിസ്ത്യാനിയെ കെട്ടാൻ പറ്റത്തില്ല കേരളത്തിൽ. ഒരു സാംബോ ഹിന്ദുവിനെ കിട്ടിയാൽ അല്ലെ, ഒരു സാംബോ ഹിന്ദുവിനെ കിട്ടുന്ന കേരളത്തിലൊരു ഇഷ്യൂവേ അല്ല. സാംബോ ഹിന്ദു സാംബോ എന്ന് പറയുന്ന ഒരു അൺടച്ചബിൾ കാസ്റ്റാണ്. അവരെ കല്യാണം കഴിക്കുന്നതിന് കേരളത്തിൽ പ്രശ്നമില്ല. പക്ഷേ ഞാൻ ക്രിസ്ത്യാനിയാണെങ്കിൽ പോലും ഒരു കത്തോലിക്ക ക്രിസ്ത്യാനിയെ ഞാൻ കല്യാണം കഴിച്ചാൽ കേരള ഇളകി മറിയും, സമ്മതിക്കില്ല അവർ.
ऐसे जो राधिका शादी के लिए होने के बाद प्यार से अथवा नागरिकता से पैसे से होने से नेक्स्ट जनरेशन उनका बेटा का भी शादी होना मुश्किल होता है, फिर अमेरिका जाता है, अमेरिका बेटी ही मिलता है, इंडियन बेटी मिलना बहुत मुश्किल होता है।
अब दूसरे जाति
there is some kind of caste and there is some kind of discrimination everywhere in the world.
But not based by birth.
All right, not based by birth. So why are you just against birth? You have a society which has just casteless and birth has got no meaning. You think that the father and son then have some resemblance. You deface the face of that son so that he doesn't look like his father.
कल को ये पैर कह दे करोड़ों वर्ष से हमारे ऊपर ये शरीर खड़ा है, हमको दलित कर दिया है इसने, अब हम ऊपर रहेंगे और सिर नीचे रहेगा। अब पता लगा कि स्टालिन सिर के बल पर चल रहा है, कहीं पागल हो गए क्या हो हैं?
So one of the commentators, Rajiv Bhargava, who's coming out of the book called Revisiting Secularism, Reimagining Secularism, says that caste is like the church in Europe. Caste itself becomes the major oppressor. So if you look at secularism purely from the angle of religion, you will not get a complete answer at all, because it's much more complex in the Indian scenario. He believes that we should therefore have our own answers instead of looking at the West as to how we should reassert Indian notion of secularism, which dates to an ancient past which included Ashoka. Interestingly, he talks of the early Vedic texts as not mentioning gods at all. So he says there can be a religion without gods in India. There was, at a particular point in Indian history, a religion without gods. So the religionalizing of India is something that he's questioning. And he's saying that we therefore need to go back and find answers through that path, where we had a much richer tradition of coexisting in different practices and beliefs, and even being atheistic. He refers to Charavaka, for instance. And this same Indian society accommodated all points of view and was able to find coexistence, peaceful harmony and coexistence side by side with the differing traditions. I could go on and on, but the point I think we need to make is this is the time to debate this notion of secularism. I know there can be several points of view on this, but we should remember that our constitution is our unifying factor. Our constitution is what we should abide by. Our constitution recognizes secularism as understood in the Indian ethos as part of the basic structure of the constitution. And our constitution is something we should believe in. It's important for law persons to believe in our own constitution. Of course, we can have a healthy debate on it. I'm sure there are lawyers who have a different point of view. I'm sure there are scholars who have a different point of view. But this must be a matter of debate. It must not lead to strife that leads to violence. That is unnecessary and not called for at all. I'm glad that All India Lawyers Union is providing a platform for this debate. I'm sure it should be a healthy debate. and it will lead to best practices in trying to resolve conflicts on much of these major issues. I think I've covered the whole gamut of what the Supreme Court says on secularism. If any of you have any questions, I'm prepared to take them. Thank you for your patient listening. Jai Hind.
Thank you, sir, for elaborating discussion on the secularism of with regard to our constitution. Thank you once again on behalf of All India Lawyers Union Telangana State Committee. ఎవరికైనా అడ్వకేట్స్కి ఏమైనా క్వశ్చన్స్ ఉంటాయి, మార్నింగ్ నుంచి ఇప్పుడు దాకా సెషన్ విన్నారు కదా, ఎవరికైనా ఏమైనా డౌట్ కానీ ఏమైనా క్వశ్చన్ కానీ ఉంటే పోజ్ చేయండి, సమాధానం చెప్పే అవకాశం ఉంది ఒక 5-10 నిమిషాలు. ఎవరికైనా డౌట్స్ ఉంటే చెప్పవలసిందిగా కోరుతా ఉన్నాం. మార్నింగ్ సెషన్లో మనము కాన్స్టిట్యూషన్ పైన కాంపిటీషన్స్ నిర్వహించి కొన్ని ప్రైజెస్ ఇవ్వడం జరిగింది. మిగతా ప్రైజెస్ ఇప్పుడు మన చీఫ్ గెస్ట్ గారి ద్వారా ఇప్పించడానికి ప్రయత్నం చేస్తా ఉన్నాం. ఈ కాంపిటీషన్స్ నిర్వహించినటువంటి ఫాతిమా, ఐ రిక్వెస్ట్ కుమారి ఫాతిమా come on to the dais and announce the names.
I would like to invite Ms. MP Stalin to come and collect the certificate. Okay, and Karunakar, the second person. Then either Ali Haider, sorry. Come. This side, this side. Stalin, where he went, right? They are coming, like in a minute or 2 minutes. Okay. One more person also. One more. Okay. There is one more. One. There is Karun. Karun. Where is Stalin? Idhar sir. I'll give it from the call here. MP Stalin. Stalin. Let's go.
క్వశ్చన్స్ ఎవరైనా డౌట్స్ ఉన్న వాళ్ళకి కార్డ్లెస్ ఇది వస్తుంది మైక్ మీ దగ్గరికి, అక్కడి నుంచి క్వశ్చన్ అడిగితే ఇక్కడ సమాధానం చెప్పడానికి అవకాశం ఉంది. ఎవరికైనా అక్కడ సార్ అక్కడ అటు వెనక్కి అండి, వెనక్కి మైక్, కార్డ్లెస్ మైక్ మీ దగ్గరకు వస్తుంది, మీ ప్రశ్న అడగవలసిందిగా కోరుతున్నాం. దయచేసి అందరూ కూర్చోండి, ఒక 5-10 నిమిషాల్లో కార్యక్రమం అయిపోతుంది.
Hello, Namaskaram, sir. Sir, Namaskaram, sir. Sir, we are hearing our country's name is going to be changed into Bharat. So, is it secular? Or, my doubt is, what is your opinion on it, sir?
The word Bharat is already there in the constitution. It says India, that is Bharat. So I don't see this having any problem at all. It has nothing to do with secularism. There should be no problem at all.
Then why media is doing so much of fuss?
So what politicians do, politicians will do
Okay.
for political purposes.
So
Let's as rational beings calmly and reflect on it and find that the constitution itself says India, that is Bharat.
okay, Bharat is okay, sir.
Yes, yes, of course.
Thank you.
As long as India is not removed.
Okay, sir. Okay, thank you, sir. Thank you.
Sir, you have said about the government removing the distinction about religious functions, the executive conducting pujas and all. But in my personal I have seen in High Court even an Honorable Supreme Court judge being felicitated by Veda Pandits on the dais.
Correct.
So
correct.
what do you say?
No,
At least
this
the
is
judiciary.
this is what we need to reflect on. See, the original notion of secularism was to keep away religion from official functions, not on private functions. I must share with all of you, can we have this recording stop?
Yeah.
See, there's a funny incident of the Hirakud Dam in 1958. Pandit Nehru was supposed to come and inaugurate the dam. We had a chief engineer who was a devout Vaishnavite. And he had fixed the function such a way that Pandit Nehru would first come, address the gathering, inaugurate the dam at 6 in the evening. This was because there was a Rahu Kal on that particular day.